Good afternoon and welcome to the August 16th meeting of the Santa Rosa City Council. Madam City Clerk, could you announce the roll, please?
All council members are present. Let the record show that all council members are present, with the exception of Council Member Carlstrom.
Thank you very much. We had no closed sessions this afternoon, no study sessions. We have one proclamation this afternoon, and Mr. Corsi has it. And we would be bringing down Diane Kitamura. Is she here? Maybe. Yeah, let's wait. We have no staff briefings. Any report, Mr. City Manager?
Nothing to report.
Okay. Mr. Roush, anything to report?
No, Mr. Mayor.
And welcome this afternoon.
Thank you.
Thank you. Statements of abstention. Council members, anything to abstain from this afternoon? Okay, I do. We did get a report back from the FPPC asking me to continue. They have not finished or presented a final decision on my ability to weigh in on rent control and just cause eviction. So they have asked that I continue to refrain from any discussion on that item. So I will be leaving the chamber on 13.1 until that is completed. And 13.2, actually. So let's see, moving on to consent. And we are going to pull item 11.4. There was a, oh, I'm sorry. No. I didn't, that's what I get for flipping my pages too quickly. Council members, reports. Mr. Oliveras.
Thank you, Mayor. I'll begin. We had our monthly subcommittee on homeless policy yesterday morning. Very good meeting. I had a briefing on the Housing First model that we'll be hoping to implement as a policy. We'll bring that to you at a future time. But a lot of work is beginning. We're moving forward with forming a technical advisory committee for that subcommittee to get a lot of the work done related to our emergency declarations, our CHAP program, and also to begin moving forward on developing a strategic plan for the city to work off of. So it was a good meeting. It continues to be very, very well attended, and a lot of new folks continue to come to the table as well, expressing concerns about the issues, but also expressing a willingness to collaborate with us and help along. Had a very busy couple of weeks. First, I want to start off by last Wednesday, we did have our annual joint meeting of the Santa Rosa Violence Prevention Partnership. I know the Vice Mayor will report out on this as well, but it's always great to have our partners on the operational team join us. We went through the process of identifying more or less a SWOT analysis as we move into a new strategic plan. Over the past couple of weeks, I did visit some of our youth from SAY at Bear Farm and the Sunflower Garden. A lot of folks have been out there involved in summer employment programs. I extended an invitation to a number of them to join me on a hike up Taylor Mountain. So we did that on Friday morning. It was great having about 15 kids up there who've never been to the top of that mountain, but a great sense of accomplishment when they got to the top. Yesterday, attended Catholic Charities event, and I know the Vice Mayor will report on this as well. Big push for back to school, outfitting the kids with school supplies, backpacks, nice little mini career fair for them. Got to see the fire truck and just a wonderful raffle that ended the day with some dinner for them as well. And then finally this morning, I was at the Chamber recognition event for local teachers. About 35 teachers ranging from preschool all the way to four-year colleges were recognized by their schools for their work and the excellent job that they've been doing over the past year.
Thank you. Busy week. Mr. Vice Mayor?
Sure, thank you. So a lot of these will be repeat from what Councilmember Oliveras was at. Regarding the Santa Rosa Violence Prevention Partnership, what was nice is that there was At 7:15 in the morning, Wednesday morning, there were over 70 community leaders, either on the operational team or the policy team. And we did do that SWOT analysis, strengths, weaknesses, opportunity, and threats, both for the community in the areas of the domains that were established the night before or accepted the night before, and then also the partnership in and of itself. So the nice part about it, that's going to be a nice first step as we start into our strategic planning process, having those 70 members actually participating even prior to us formally starting the strategic planning process. So that was great. I also attended the SOI Garden Open House, and I really encourage the community, check it out if you haven't. It's on A Street, right next to the Family Support Center. And what was nice is that a lot of the tours of the garden were led by the kids who actually have grown the produce. So there's a lot of learning that's going there. And additionally, the produce from the garden actually gets donated to the Family Support Center. I mean, hundreds of pounds of produce there. So it was great to be part of that. Attended the homeless subcommittee meeting. The back-to-school assembly at the Family Support Center on Monday was nice because it was also combined with the College Tea Project. And for those of you that aren't familiar with the College Tea Project, it's showing kids to keep the hope that college actually is an opportunity for all. And they talk about the indicators of success in college as if your parents attended college, and many of the kids who are at this event are actually staying in the Family Support Center. And so showing that there are other community members willing and able to help them achieve those goals. It was nice tying it into the back-to-school event. So it was great seeing many city departments out there and even seeing the Coast Guard and park rangers out there. The kids really enjoyed that. Then lastly, the chamber event this morning, recognizing some of the education and business leaders, and they talked about the importance of career technical education. And I do want to give a shout out to Ronit Rubinov, who is recognized from her Empire College position as one of our excellent educators in the community. So wholeheartedly agree, and I appreciate your attendance both this morning and at this event. That's it.
Good job. Busy as well. Anyone else? Sure, Ms. Combs.
Thank you. I took part in a back-to-school supplies event at the Migrant Education Program. These are legal workers, migrant workers here who have children with needs. I also attended the homeless meeting on Monday with my colleagues, and I have a couple of questions about that. And one of the concerns that came out of that meeting was a concern that we were going to run out of time for the upcoming winter weather. And we had discussed the possibility of asking council to save some kind of date at the end of September or the beginning of October, so that when we've finished with the technical advisory committee materials at the subcommittee level, we can be sure that it makes the agenda in a timely fashion. So I'm just making, we had talked about that, I'm just reinforcing that we made that request.
Thank you.
Thank you.
Anyone else? Okay, moving on to consent. Excuse me. I am going to be pulling 11.4. There were a couple of typos in the staff report that need to be corrected before we present this item, and we will be bringing it back for council approval. So actually, we have to reintroduce it. So we will be basically starting again with this item. So I'll be pulling 11.4. Mr. McGlynn, consent.
Item 11.1, resolution, donation from the Santa Rosa Tennis Club to resurface courts 9 and 10 at Galvin Park. 11.2, resolution, amendment to the classification and salary plan to add 1.25 FTE to the Code Enforcement Division of the Housing and Community Services Department. 11.3, resolution, Courthouse Square reunification project, authorization to install and remove temporary mid-block crosswalks on 4th Street.
Thank you very much. Council, any questions at this point? Mr. Wysocki.
Thank you, Mr. Mayor. 11.2, does this addition in staff, that just brings us to staff levels projected to enforce our current policies?
What it does is it adds one temporary part-time technician for 1 year to deal with the backlog of our level 3 nuisance cases only. We are fully staffed. Well, we have 5 positions in that division, and we have 4 filled, and we have an offer to another candidate to take the 5th permanent spot.
So, okay, that brings us to our budgeted level, and that's going to promote our current level, which is basically complaint-driven.
Correct.
If this council wants to change the policy and have a more aggressive inspection program on rental units, when will we see that?
The rental inspection program that you've expressed an interest to have us design, the studies we're working on are due at the end of September. We're anticipating a mid-October presentation, and that's the timeline we're on for the proactive rental inspection program.
And the mid-October presentation, would that be in a study session form or a report form for adoption for council action?
Well, that's my recommendation to the body is we check in with the council first, make sure we're on the right track, get clarification on, the costs to support annual inspections every 5 years, and then based on that feedback, it would be my suggestion. Then we go to the community, the Apartment Owners Association, the Board of Realtors, other stakeholders to get their feedback. That is what I would be proposing in the fall.
So the timeline on that for implementation, should we decide to have a different program, would be end of the calendar year, approximately. That's what it sounds like.
Yes, sir.
Not as quickly as I had hoped, but I guess
I
we
think
have
tonight's
limitations.
conversation was where we needed to focus our staff energies, and so that's why this came first, because we're in a urgent state, and we have a moratorium in place, and we need to address the current state of affairs, and we have limited resources to be able to tackle issues. So this came first, sir.
Which is understood. I'm just concerned with checking in with council prior to an election, and it'll be in a totally different council after the election, because 2 of us won't be here at least. And that in terms of staff resources.
I'm at my limit. Last week, we declared a homeless emergency. I have to be honest, we're at our limit as it relates to some of what we're able to devote to programming and get regular work done.
And I understand. Just wanted to raise the issue. Thank you.
Thank you. Any other questions, council, before I move to public comment? Mr. Canini, and he will need the overhead projector, Madam City Clerk.
Mayor, council members, ladies and gentlemen, I don't know how well you can see this, but basically this first question or the first comment is that this old courthouse square, what's it called there? The tax-exempt general fund lease obligation, raising the money for this project. That's basically a tax scam. It's a gift to Wall Street and the 1%ers. It's kind of shocking that a government entity would involve itself in a tax avoidance program. And this is particularly egregious because this very same body, which is cooperating with this tax avoidance scam, will ask the good people of Santa Rosa to vote in favor of a sales tax this year. And a sales tax, as we know, is the most regressive tax, the most regressive. You're even taxing meals at the fast food place, and as you probably know, fast food restaurants are keeping the poor in this country alive with fat and sugar and salt, but that's where they survive. This courthouse square will have parking spaces which will be metered. The money from those meters is going to go to the downtown business parking district, not to the general fund. And it's the general fund you're using to justify this tax increase. Most of the cost of that courthouse square, better than 97%, is coming out of the general fund, cash, and then all the finance charges that will be paid to Wall Street. But the money that it generates, that don't go back to the general fund. That goes to the downtown business parking district. Something wrong there. If you have a problem with the general fund, don't engage in tax avoidance scams. And when you use general fund to build parking spaces, put that money back into the general fund. How about the meters on the other streets in Santa Rosa? Where does that money go? Does that go to the general fund? Public ways, public streets, built out of the general fund, built by the taxpayers? Who gets the money from those meters? I think it's the downtown parking district. So the betrayal of the 99% is not limited to DC. It's happening right here in this chamber. Thank you.
Thank you, Mr. Canini. Those are all the cards I have on consent. Mr. Vice Mayor, you have the calendar.
Thank you, Mr. Mayor. I'd move consent item 11.1 through 11.3 and waive further reading of the text.
Second.
Thank you. I have a motion and a second. Your votes, please. And I have 6 ayes with Councilmember Carlstrom absent at this point. Moving on to 13.1, and I will excuse myself.
Thank you. It has 5 o'clock. Item 13.1, report, consideration for adoption of an ordinance of the City of Santa Rosa adding Chapter 6-90 to the Santa Rosa Municipal Code regarding 1, residential rent stabilization and other tenant protections for certain rental units within the City of Santa Rosa, 2, a resolution adopting a policy concerning capital improvement plans for certain rental units within the City of Santa Rosa, and 3, review of preliminary cost estimates for program administration through June 30th, 2017. David Gwine, Director of Housing and Community Services, presenting.
Thank you, Sean. Good afternoon, Vice Mayor and City Council members. Joining me in today's presentation is Michael Rausch of the Public Law Group. He is certainly the primary author of the ordinance by which we're reviewing tonight, as well as Stephen Boshin of Management Partners, who is the primary author of the administrative costs of the proposed ordinance based on our review of cities with similar structures. As Sean mentioned, the purpose of today is the 3 items to be reviewed, 2 ordinances and the review of the costs. We plan to go through some high-level slides to just touch on the overall framework of the ordinance, and then collectively we're here to answer your questions. So quickly, by way of background, we're relying a lot on the discussion of your May 3rd meeting, where you outline the components of which you'd like to see in a rent stabilization ordinance and the just cause. And that was refined a little bit on May 17th when you enacted an ordinance imposing a 45-day moratorium on rent increases, directing us to come forward with a comprehensive rent stabilization program. Again, in July, you adopted an ordinance extending the urgency for 90 days, which would bring us to roughly early October, October 3rd, 4th timeframe. And then July 19th, you had to do some corrections to that action of July 7th. So overall, the proposed ordinance includes the following. It rolls back rents to the level where they were at in January of this year. And it allows rent increases to be no greater than 3% a year beginning January 1st of 2017. It also outlines a process to consider greater increases, and we'll go through that today. It allows termination of tenancies only for just cause, and requires the relocation payments for no-fault tenancy terminations and substantial rehabilitation, for example. And there are some exemptions to the units in the ordinance that we'll also speak to. So what rental units are covered by the ordinance? Primarily multifamily rental units built before February 1995. That's based on state law, the Cost-Hawkins Act, which prevents jurisdictions from limiting rents on units built after that date. It also exempts duplexes and owner-occupied triplexes if the owner is the principal resident. So again, we won't be touching single-family homes and condominiums, the duplexes and triplexes where the owner resides in one of the units, as I just mentioned. Units built after February 1995 threshold. Units also regulated by governmental agency or by agreement. Those would be units constructed or regulated by your Santa Rosa Housing Trust or the Housing Choice Voucher Program, for example. And it doesn't contemplate addressing rooms in single-family homes. So let's talk a little bit about rent increases. As I mentioned, it rolls back rents to the January level. It allows just 3% increases annually. And the first increase would not take place, and one time only, January 1st of 2017. And then there's a process for landlords to be considered for rent increases greater than 3% through the administrative process, which we will describe. So let's touch on the process to obtain a rent increase greater than 3%, but not connected with the capital improvement plan. So a landlord would file a request with the program administrator. That is the ordinance contemplates that to be the Director of Housing and Community Services, and we'll get into the staffing level of that later. If no agreement can be reached between the tenant and landlord, they may file a petition for a hearing officer to hear the matter. So the first step is the program administrator to consider the request, and if we can't come to resolution, it's suggested to go to a fair hearing officer. The program administrator and the landlord are the parties at the hearing, and this mirrors the process the city currently has in place with the code enforcement program and what we would contemplate to be the process for the yet-to-be-established rental inspection program, where those disputes, those considerations go in front of a fair hearing officer. And of course, the hearing officer's decision is final and binding, but always they're subject to judicial review. That is to say, one of the parties can appeal to the courts. Did that just advance? Yes, okay. Similar title. So let's talk about the process to get a rent increase greater than 3% in connection with the capital improvement plan policy. That's the second ordinance you're considering tonight. So a landlord would submit a capital improvement plan to the program administrator, and they would apply a mechanical formula to determine the rent increase over the cost of the improvements for a period divided by 15, the amortization period, then divide by the number of units. And we suggest a formula approach to that consideration for reasons that Michael can certainly dive into later, but that's the experience that we see from other communities. What is a capital improvement plan? It's designed to encourage reinvestment in real estate properties. It ensures landlords to receive a fair rate of return on their investment, and it provides tenants with relocation benefits if they're required to relocate during the course of the work. And the capital improvement plan talks about the relocation either within another unit on the property or if they have to go off-site. It gets into those details. Capital improvement plan criteria, material value, or if it adds material value to or prolongs the useful life of the property. So it contemplates a real investment, not routine repairs. So we cite those examples like new HVAC systems, re-roofing, things of that nature. And here's where the formula comes into play. The cost must be at least 8 times the amount of the monthly rent multiplied by the number of rental units being improved. And so we can go into more detail on that if you have questions. The ordinance also outlines a process for a tenant to obtain a rent adjustment. So a tenant may request a rent adjustment based on perhaps a miscalculation of the rent or a reduction in housing services or some version of why they would think the rent should be reduced downward. Again, the program administrator would be the first point of evaluating and making a determination on that request. And then if either the tenant or the landlord disagrees with the program administrator, they would file a petition for a hearing in front of the officer. And again, the hearing officer's decision would be final and binding, subject to an appeal to the courts. So a couple of comments on the limitation of terminating tenancy. So this ordinance no-cause evictions are prohibited. That's the just cause eviction consideration. It allows, though, however, for for-cause evictions under the law. That's examples are cited here in the slide. Failure to pay rent, they're habitually late, breach of lease, nuisance, things of that nature. And that also speaks to no-fault evictions, which are permitted. That's where the owner moves in, there's demolition or substantial rehabilitation, going out of the rental business or a government order, say a code enforcement action, things of that nature. And in that case, the relocation discussion comes into play. Here in relocation assistance, so we suggest for you this evening that it apply to the no-fault evictions. It's the equivalent of 2 months' rent plus $1,500 as a stipend for costs, and that $1,500 would be adjusted annually based on the Bay Area CPI. And we would require the landlord to pay half the payment up front. Quickly touching on the landlord's obligations to tenants and purchasers, there's a lot of noticing. So it provides existing and prospective tenants a notice that the rental unit is subject to the ordinance, provides a copy of the ordinance, city policies, things of that nature. And it would be our intention as staff to develop those notices so that there's consistency. Landlord's obligations to file documents with the program administrator. So that would be, rent increases greater than 3%, any and all capital improvement plans. When a landlord or tenant disagrees with the program administrator's decision, notices to terminate tenancies for no fault. If an owner's moving in, documenting the name and relationship of the person, documentation if the property is being removed from the rental market, and also tracking relocation payments. Those would be paperwork that the landlord would be responsible to file with us. Annual review and when the vacancy rate is above 5%. So based on your May 3rd discussion, you had if a consideration that the ordinance would go out of play, or my word, be suspended if vacancy rate was sustained at 5%. So we add in the ordinance that we would go back to the council, reporting annually on the program effectiveness, the program costs, what we're learning about the program, where we might be suggesting amendments, things of that nature. And then, of course, in that year, if we can document for you that vacancy rates are above 5% as other factors, it would provide you with the discretion on whether you wanted to adjust the ordinance or suspend it accordingly. Then a couple comments on the program fee. As we understand the direction from the council on May 3rd, you're looking at a program fee to the property owners. We'll get into how we are currently estimating that to be between $1.1 and $1.4 million based on the number of units subject to the ordinance and the cost to administer to the program. Half the fee may be passed on to the tenants, but it cannot be included in the rent increase calculation. Our current estimate is that that would cost a unit between $102 to $125. We plan on refining that by the August 30th report, where we'll, based on your feedback today, we will nail those cost estimates. And finally, with the startup cost to get to the fiscal year through June of 2017, we estimate that to be around $744,000. So that is a general flyover review of your ordinance. The recommendation, as Sean mentioned to start, we are suggesting you add a completely new chapter to the Santa Rosa Municipal Code entitled 6.90 regarding residential rent stabilization and other tenant protections. We also ask you to consider a second resolution concerning the capital improvement plan policy, and then review, comment on the preliminary cost estimate to administrative program so that we can return in 2 weeks for you to act on that fee structure. That concludes our formal presentation. We are here to answer questions.
Thank you for that presentation. Council, questions for staff? Mr. Corsi.
I know there are going to be a lot of questions, and I'll defer to my colleagues to start the questions, but I wanted to ask this first, and that's process for tonight. I know based on feedback we've received from the public and my own review of the ordinance that there are going to be a lot of discussions about whether this is the right way to do it, the details of this. And what I'd like to know is how you envision us getting through that and making decisions about the details tonight or some other time. I'm hoping that we can do it tonight, but I just want to, before we get into this, I'd like you to let the council and the public know what the plan is.
Yeah, and we discussed that prior to the meeting, and as staff, we would consider what the nature of the comments and feedback are. So if there are points of clarification, for example, or maybe some minor wordsmithing to, say, for example, clarify demolition and reconstruction, we will probably make those changes for you to consider at the second reading. However, if there's substantial changes or new pieces we haven't contemplated or we completely missed the mark, we would return for you to review that ordinance first. In other words, it would be like tonight, but with the changes you suggest. And then there would be a second reading to follow that.
Other questions?
Do you consider questions, comments on the document itself? Is that questions, or is that, well, when I say comments, edits, are edits questions? Or do they come after public comment?
Councilmember Combs, we can do it either way. Certainly, if there are particular questions that any of the council members would like me or members of the staff to answer, glad to do that at this point. You know, that would not be unusual.
Can you also give us a sense of the timeline? If we have, we're scheduled for a second reading. If this is the first reading, we're scheduled for a second reading. If this isn't the first reading, is the second reading the first reading, or is it delayed further than that?
I think it's all going to, you're asking me to speculate, or you're asking us to speculate. It depends on what we said earlier. I think
Okay.
Mr. Gwine was correct. It depends on what the action is that's directed from the body. This is staff's, this was really hard work with the team to get to this point in a very compressed period of time. We will have to hear what the direction is to respond to that. And again, to the question and edit situation, I would say it depends on, is it fundamental edits? And then, you know, so if we're going right into, I want to change this, I think that needs to go back to the body for a conversation about a change of substance.
Yes,
if you're asking a question, then we can field the question.
Okay, I do have questions in addition to some other things. So first, I do want to say thank you. I do appreciate the speed with which this has been moving along, and I appreciate that you've worked hard on this, and I thank you very much for that. I have a question about the program administrator and what that means. Can the program administrator, as talked about in here, be the housing authority or the housing authority plus staff, or is what does program administrator in this document mean?
As contemplated, it would be either a staff person or a person or organization with whom the city would contract, at least initially, in order to administer the program. This program is reasonably complex, and staff's thinking was that it would be simpler in order to get the program up and running to simply have a staff member or a consultant be the first program administrator. If the council direction is that it wishes to see the Housing Authority or some other body be involved in this rent stabilization program and gives that direction to staff, we could bring back to the council a revision, as it were, as to how that would work. But I think the thought was that that would just be too many.
Excuse me just a second.
Sure.
We've got an absent person's machine beeping. Okay, we got it. Thank you.
Yeah. Thinking that because of the program and its somewhat complexity, that would be easier to have a staff member or consultant initially run it.
Yes.
But it
So
would
we're not
be-
locked into an entity, and the Bird Program Administrator allows us flexibility in the future.
That's correct.
Perfect. Would we anticipate that the program administrator would bring back updates on procedures, processes, suggested corrections? We may be wonderful and fantastic, and I know that we all are just top-notch, but we might not be 100% perfect in everything we do. So I'm guessing that we might want to make some adjustments or iterations as we go along. Would we anticipate that those would in addition come from a program administrator? Is that part of the role?
That is correct. I think it's fair to say that
Okay.
This ordinance is probably far from perfect in terms of how it will be implemented, and amendments will be necessary.
And we had discussed an education component in the past at the other previous meetings. I don't see that referenced here. Will an education component come forward as we move forward?
Yeah, it is not listed specifically in the ordinance, but it's our intention through the administrative rollout to do that first.
Okay.
And so it's built into the administrative cost initially.
Thank you very much. Is it possible, what I notice is that the process as outlined here, we have a hearing officer, and then it seems to become a judicial process. Is it possible to add an administrative appeal step, or is that a not legal action? Is it possible to say, after the hearing officer, it goes to an administrative appeal before it goes to court? And part of my intention with this was that I'm trying to keep it friendly, and some of the friendliness is to keep it at an administrative level rather than being in the court system. Is it possible to do that?
The answer is yes. It may be better if the administrative appeal process maybe would come in between the program administrator's decision and the hearing officer. If we're trying to keep it friendly, or for lack of a better word, maybe try to
Okay.
mediate the dispute, that process probably works more efficiently before it goes to a more formal hearing process.
Okay, I would be receptive to seeing that if we need to bring it back in some way. That would be I would be very interested in that, just because, as I said, there is a sort of keeping it in-house friendliness and not a overwhelming.
I
the
do
courts.
want to be direct that when we add layers, we potentially add costs. So
Okay.
as we add those steps, I don't want it to seem that this is why we get some direction. The program we've laid out has a certain cost associated with it. But as we add more layers to those processes, we potentially add more costs.
I'm open to the conversation. On page 6, I'm a little confused between a definition of the owner and the rental unit owner occupancy for triplexes, because the definition of an owner references an owner's agent. And I'm wondering if that means that an agent for the owner can occupy the triplex as opposed to the owner occupying the triplex. Can you clarify that for me? I'm not clear.
I think the intent there was to, by qualifying the owner occupant with respect to the triplex as the person's principal place of residence.
Okay.
I think that was the intent, but I certainly see your point that you could still have the argument that an agent of the owner, was that person's principal place of residence. So perhaps we would need to
Yes.
tweak that language a little bit to make that a little less ambiguous.
I'm just concerned that a property manager might be acting as the agent of an owner but not meet our intent of the owner occupancy. I have a question about 690.040B on page 8.
G as in girl.
B is in boy.
Thank you.
I have some, while I like the concept that landlords and tenants or renters have conversations and don't mind facilitating conversations like that, one of the reasons we would be putting an ordinance like this into place has to do with an unequal power dynamic of the tenant and the landlord. I have some concern and wonder if you can address that. Is it typical to allow an ordinance to be perhaps superseded by a private waiver from a tenant to a landlord? I'm not aware that we do that. For example, a person who receives minimum wage can't waive the right to minimum wage. Can we do the item B?
The concept was less about waiving something than trying to recognize that rather than putting a landlord and potentially a tenant through a hearing process, that should we not be trying to encourage the parties to negotiate something that might be above the 3% but still might be acceptable. There is the risk, obviously, that a landlord could have coercive efforts with respect to a tenant and thereby somewhat negating the purpose of the ordinance. But I don't think it's unusual to have in an ordinance that it contemplates that there can be a process to allow the tenant and the landlord to reach an agreement that might be different than what the allowable adjustment might be.
Can that process be a process that takes place with the hearing officer or with the program administrator involved rather than simply requiring a signature from a tenant that they have capitulated out of, we don't know what level of fear or coercion? I'm just very concerned about, we don't pass ordinances because of the good actors, we pass ordinances because of bad actors.
And I think the answer there is yes.
Okay.
If it's the council's direction, we could add some language there concerning, in section B, indicating that there has to be the concurrence of the program administrator before that agreement would be final. And that way, at least there is the neutral body, not the hearing officer per se, but the program administrator who would at least have the ability to say, you know, I'm finding some coercive effort here and I don't like it, and could bring some relief, as it were, to the tenant if there's some coercive effort going on. That could be added if that's council's direction.
I think I will be interested in hearing comment on that item, just to know what the tenor of the community and the rest of my council is on that one. It concerns me. That actually appears in multiple locations in my notes. So it reappears on the bottom of page 10 in dash 90.065 in the bottom of page 11. So depending on how we make our decision about that, it needs to be consistent throughout the document.
Correct.
There is a notice listed on 90.065 that does not appear to notice the tenant of their rights. And I'm wondering if that's a typical way that we notice under civil code, that the landlord provides a notice of what the landlord's intention is, but does not include an indication of the tenant's rights. For example, a right to file information or a right to counter the request or a petition to be heard from the tenant. Is that something that we should be considering when we give notice to tenants?
The notice in 065 is really in context of when a rent increase is being given. And certainly the...
Okay, it says propose specifically.
I'm sorry?
The word proposes a rent increase rather than that has been approved of one.
That is correct, but the notice is being required when the landlord proposes to increase the rent above the allowable annual adjustment. The tenant would have been advised generally when the tenant is advised about the ordinance that the tenant has the right to seek a rent adjustment based on reduction in housing services or other reasons. Certainly, we could, if the council wishes, we could create a separate section that would require a landlord say at the start of a tenancy to provide some type of formal notice like in 065 that would more specifically tell the tenant that he or she has the right to seek a rent adjustment based on the criteria in the ordinance. It's in the ordinance, but we could create a separate notice.
I'm more concerned that if the landlord is providing a notice to the tenant, and that's what I think I'm reading, greater than the annual allowed increase, that the tenant's rights should be in the note, that first notice, and not require the tenant to remember something that may have been distributed to them prior to move-in.
Maybe I'm not fully understanding your question. As long as the rent increase is 3% or less, the landlord is not required to provide this notice to the tenant.
That's correct.
Okay, so I guess I'm not clear about what you would like the tenant to be advised of in this particular notice, because this is the notice to the tenant that the landlord has requested this and has filed something with the program administrator, and that the program administrator will, do certain things, et cetera.
So the tenant needs to know if the tenant can attend the hearing. Can the tenant file materials? Can the tenant make a comment? Does the tenant have a right to be heard? That's not clear, and it's not clearly required, like a phone number. Who does the tenant call? It seems to me the notice is insufficient for protection of the tenant.
I see your point now, and the answer is yes. We could add a paragraph in here dealing with those particular issues if that's the council's direction.
Thank you. And then the reaching agreements are on page 11 at the top, and I think item D also mentions them. The tenant in 6-90.075 has some requirements that seem unusual to me, and I'm just wondering if you can explain them to me. One of them is a requirement that 2 or more tenants make the request, and I'm trying to figure out if, for example, a tenant's parking space is removed, that tenant may be the only one who has a complaint or a concern about a reduction of service, and yet we are requiring them to provide another tenant to join in their action.
I think the thought process there, or I know the thought process there, was to prevent perhaps a tenant who might be just a disgruntled tenant from filing what might be a frivolous petition concerning a matter. And so the thought was if 2 or more tenants would do it, it would be less likely for that frivolous matter. But it's entirely, there's no magic to it.
If we are going at being frivolous in recurrent attempts, I would prefer we address that directly and not limit a tenant who may be the only one who has the problem to having to convince another tenant to join them in their action. It also concerns me about the once every 12 months, because if a tenant takes an action and then there is a retaliation for the tenant's action, they have to wait a year before they can bring notice of the retaliatory action. And that doesn't seem fair either. And I take it that that's probably also addressing the concept of frivolous. And I'm willing to consider the concept of frivolous, but not in this way.
Understood.
There's also a 30-day limitation on the tenant, and yet I don't see similar language regarding landlords. So I'm concerned about why there's a 30-day from the date of the error on the tenant.
The thought process, the reason for that was that with respect to the landlord is required to file with the program administrator within 15 calendar days of the request that the landlord wants the rent increase above 3%. So there is a time limit there. The thinking involved in the 30 days here was that there was a sort of a timeliness issue, so that if there was a miscalculation, et cetera, that the tenant would have some obligation to bring it to the attention of the program administrator and the landlord in a timely way. The 30 days, it could be extended. The council's direction is that it was simply a timeliness issue.
I would be interested in knowing what other ordinances use, if they use 30, 60, 120, what other time periods are available. In 90.080, that's the unrelated reasons. Item 2, B is in boy 2, mentions historic buildings. I don't have any problem with the inclusion of historic buildings because of the high cost of modification to them, but I'm trying to figure out how we are defining historic buildings. Do we have a definition of that?
There is no definition of historic buildings in this ordinance, so presumably it would defer to your municipal code if you have an architectural heritage district, for example, or in the zoning code perhaps. If there is a more precise term that would be otherwise contained in your code already, we could make that change so that's consistent.
Okay, so these would be changes that might have been approved by our Cultural Heritage Board, for example, which reviews modifications to historic buildings. If there's a way we can make that clearer, perhaps by adding a reference to that in the definitions. I don't accept item 5 on that list. I'm concerned about 7 and 8 and want to understand them more fully. My understanding is that if there's a government order requiring maintenance and repairs, that we've dealt with that. But this sounds like some fairly extensive maintenance and repairs that would be on the edge of habitability code issues and health and safety code issues. So I'm a little concerned about what do we mean, what are we getting at on these two? 7 and 8. If we don't want habitability to become an excuse to evict.
Right. And these are grounds by which the program administrator and then ultimately the hearing officer can take into consideration with respect to whether or not to grant a rent increase above 3%. When the improvements are not related to an approved capital improvement plan. And
if the building has been neglected for a substantial period of time and then purchased by an investor, would that qualify under these two, that the investor has decided to upgrade the building?
The answer is yes, it could. In other words, if an investor bought a building that was run down and now wanted to make improvements to that property, but it didn't reach the threshold dollar amount under the capital improvement plan, then the landlord or the new owner could make a case with the program administrator and with the hearing officer that he or she had to make a certain amount of improvements to the property because of the deteriorated conditions, and based on those costs, seek an increase above the 3%. So it would allow the program administrator and the hearing officer to take that into consideration. But by contrast,
Is
the
that
program-
different from number 3, in which we've said capital improvements unrelated to the capital improvement plan? Because I'm really having trouble with sort of funding neglect of a building.
There's a certain similarity between 3, 7, and 8. There's no question about
Yeah.
it.
I don't have a problem with 3 and giving the judgment call for a capital improvement. I'm having problems with maintenance and repairs being funded because they should be funded under the ongoing costs.
7 and 8 clearly are somewhat subject to a great deal of interpretation, and if the council is satisfied that number 3 addresses the issue adequately, 7 and 8 could be deleted.
Thank you. I appreciate
May I
hearing
ask a
that.
follow-up on this very point?
Please do.
This, to me, seems like it's a big exemption to a capital improvement plan being filed, just by its very nature. So it looks like a hole big enough to drive a truck through for not filing a capital improvement plan. I don't see the need for this. Please tell me why it's needed.
Well, remember, a capital improvement plan has a threshold amount of investment in dollars, and we're proposing a formula. You could conceivably have a property that was acquired that, through no fault of the current landlord, they are inheriting a property that is deficient, but does not meet the capital improvement. And this, I think the language here is to allow some flexibility in the conversation of a good actor. And again, I think that what the council member is pointing out is some ambiguity that might open it to a bad actor. But I think the intent here is good actor acquires property. The capital investment does not reach the capital investment threshold as we've proposed it, but this allows some negotiation point on some investment so that the property does not continue to deteriorate, or we discourage those properties from being actually rehabilitated at some point.
I can understand that, and I can understand the need for discretion. Could we not make that an amendment to a qualification for a capital improvement plan? Make it a positive as opposed to a negative, is another way of putting that. I don't like the idea of an exemption to a capital improvement plan. Just make it, this can meet the capital improvement plan, so we can help those good actors that have bought the decomposed building, if you will.
We could,
If you follow.
the capital improvement plan policy certainly could be drafted in such a way that there isn't a threshold amount. So if the improvement in question meets the criteria for what is a capital improvement, then all of that could be considered under a capital improvement plan rather than through the program administrator under this section, if that would be the council direction, as opposed to having only those that have substantial dollar amount improvements go through the capital improvement plan.
Yeah, I appreciate that. I don't know which is superior in terms of
Well,
Can we make
I'll
the
put an
dollar
offer
amount
out
more
there.
clear
I mean,
here also? Excuse me.
Sorry about that, didn't mean to interrupt. I'm just trying to follow up on the council member's question. I think a little bit of this decision-making is to make it, actually to establish some bright lines which become easier for everyone, and that's the reason we have the capital improvement threshold. This is clearly qualifying as a capital improvement so that everybody understands. They understand, the landlord will understand what kind of documentation they need to bring to the table to demonstrate said improvement, and it makes some of those conversations easier. As we blur this and make that blurry, I think that's where, I'll be honest, that puts more onus on staff and potentially really challenging decisions. So I think as Mr. Roush said, if we get direction and we can simplify this, I would prefer a simplify of the exception as opposed to a revision of the capital improvement plan because of that issue. Then staff really is lost in sort of making decisions. This gives them a framework to make those understand and make some of those decisions, council member.
I appreciate that. Perhaps then we can detail or specify the instance you just raised. And maybe staff may come up with one or two others, because I don't like the I don't like the blanket discretion here. I want it to be more precise, is what I'd feel more comfortable with. Should my
I
colleagues
think I'll
agree?
be interested in hearing comment on this item as well. So I'm thinking about it, and I will hold final consideration till, we've had the comments. Can you explain 9 to me? Why is it an exception that the tenant has mental incapacity? It seems to me like that's a vulnerable tenant, and we shouldn't be making a specific exception for that. I'm on page 13 in the document.
The case law which has developed with respect to rent control ordinances, what has happened is that a landlord will come in and want a rent increase. Say, for example, that there has been an elderly person living in a unit for 20 years, and because of that person's income, the landlord has not raised the rent, or has raised the rent very minimally over some extended period of time. That tenant then moves out, or goes to live somewhere else, and because of the rent control ordinance, the landlord would not be able to raise the rent to what might be fair market value.
Excuse me, because we allow decontrol between tenants. So I'm not, if the tenant has moved out, I don't understand why it's not returning to market rate. Why do we have to go through this process?
Let me think about that and then give you an answer shortly
Okay,
on that.
I have some concern, because I think the people I really want to protect are the ones you just mentioned, the seniors, the people with disabilities, who, if their rent was suddenly increased by a substantial amount, would be on the street.
Okay.
So think about that.
I will. Thank you.
I'm concerned in this section, I'm not sure where it would go in D or E. I'm looking for due process for the tenant in the context of this section, .080, and I'm on page 13. I'm not seeing due process rights for the tenant. I'm not seeing anywhere where the tenant has a right to provide documents, to appeal, to have a hearing, rear rent increase here. It doesn't appear to match rights outlined for the landlord in the section .090. Section 090 says that if a tenant puts in a protest, the landlord will be noticed, but if the landlord wants to put in a request for increased rent, tenants aren't noticed. So it seems to me these should be reflective, and that the tenant should have due process rights to take part. I appreciate this was written fast.
I believe that the idea here was that the program administrator, by evaluating this request, would be in essence representing, as it were, the tenant's interest. And it would only be in those situations where if the landlord disagreed then ultimately with the program administrator's decision, the landlord is the one that files the petition, and then the program administrator essentially is at the table defending the program administrator's decision with respect to the rent increase. We certainly could, if that's the council direction, add a provision in here that would give the tenant the right to be at the table along with the program administrator, similar to what we have under the tenant's provision. This goes along with your previous comments about advising the tenant of what rights the tenant might have in other situations as well. So the answer is it could be added here.
I have a preference for that addition. I think that a person's rights are better if they have the right to speak for themselves. And I think that the program administrator should be a more neutral body in this process. The tenant should advocate for themselves, just as the landlord is allowed to advocate for themselves in .90. And I have marked 090BC. Okay, so the program administrator, when the tenant complains, this is the same discussion, where we're looking in .090 and seeing B and C, where the landlord is receiving contacts with the program administrator that the tenant does not receive in the above section. And I'm concerned on page 17, I believe it's section 90.125C. It reads to me as if a failure to renew is equal to an eviction. And I think that, it doesn't read to me as if a failure to review is an eviction. And I have some concern about tenant holding over after expiration of a term of lease. That looks like a major hole. Essentially, a person can be evicted without cause simply because their one-year lease or their one-month lease has come up. So that's a concern. I would strike the end of that sentence unless there's a reason we are viewing a failure to review it as an eviction and then renew it as an eviction and then not taking it through the same process. I mean, they can give a just cause to evict at the end of a lease.
With respect to the second item concerning the fixed lease as the term suggests, is that, let's say you start your tenancy on September 1st, 2015, and you have an ending date of August 31st, 2016. This ordinance would allow a landlord to evict a tenant if the tenant holds over after the termination of that fixed-term lease. That's the way
I think that's what I'm not understanding. If the tenant doesn't pay rent, there's a just cause to evict. If the landlord wants the property for their own use, there's a just cause to evict. But if a landlord wants to raise the rent to market rate, they don't have rent control if they are automatically kicked out at the end of a one-year lease. So I'm not. Maybe maybe this is a term of art I don't understand.
No, I think you have identified the problem with a fixed-term lease is that it does not provide a tenant with protection. The counterbalancing issue, though, is whether a landlord wants to go through a yearly process of having a tenant who presumably has been a good tenant, making the payments monthly, to now have that tenant leave and then have to go out and find another tenant. Typically, in what are called fixed-term leases, there is a provision that indicates that it rolls over to a month-to-month if the landlord accepts rent for that first month following the end of the quote-unquote fixed-term lease. But as written, if the landlord truly wants that person out at the end of that fixed term, then that person would have to leave, and if the person did not, it would be grounds for an unlawful detainer action, and after that person was removed, then the landlord could raise the rent to whatever the landlord chose to do.
Yeah, I'm not okay with that.
Fair enough.
Okay.
Similarly, on the issue I think you also raised about the refusal to renew a tenancy, that's in subsection E of that.
And I withdraw my comments that I may have made earlier on that one. I understand that provision now, and I think that if the tenant refuses to renew, that I understand the actions taken there. So if I'm willing to hold E, I'm certainly not willing to hold the last sentence in C. Thank you for your patience. I'm concerned about I, capital improvement plan on page 19. I'm concerned that allowing this as a reason to terminate a tenancy creates a large loophole. So I'm trying to figure out why we don't handle this the way we're handling temporarily needing to relocate people. Typically, at least my understanding is that there's a right of first refusal to return, and I don't see that language.
In the policy itself, the capital improvement plan policy, it does address that issue. It provides that once the program administrator has determined what the appropriate rent increase should be based on the formula, the landlord informs the tenant of what that rent increase will be, and the tenant has the right to either accept that or not. And if the tenant chooses not to accept that, then the tenant would be entitled to relocation benefits under the proposed ordinance. The policy also provides that there's a presumption that if the tenant has to leave the building because of the work, and that work can be completed within 6 months, it's simply a temporary relocation, not a permanent relocation, and the tenant has the right of first refusal to return to that unit, albeit at the higher rent.
I find that unclear in I. And if there's a way we can make it so that it doesn't just say they can take action to terminate a tenancy, I'm seeking comment and language on that. Point 13 or point 130. I have some questions about what the month rent is that we are referencing. Are we referencing the existing month rent that the individual is currently paying, or are we anticipating that this means the market average month's rent that they will have to put as a down payment when they move?
As written, it is the current rent that the tenant is paying.
Which won't cover their deposit needs for first and last month's rent in a new, not rent-controlled unit.
The concern was how to define what that would be, because depending on the size of the unit and where the person would move, what is really an average month's rent for a non-controlled unit. And because of the uncertainty of that, it was thought better to have the certainty, recognizing that perhaps that month's rent would be less than what the new rent might be. But the idea is by adding the other $1,500, that would help balance that out.
Okay. Some of the other entities that I've been reading about also specify something about the vulnerability of the tenant. For example, senior or elderly, disabled, persons with children. It can be much more difficult and more expensive for those folks to move. So sometimes a second tier of vulnerable tenants is added. I believe I've seen as much as $18,000 for a vulnerable tenant. And so this is not looking sufficient to me, but I'm open for comment about what is correct. I think LA's done a fairly extensive research on what it costs to relocate tenants. So I think $18,000 is a lot, but I mean, maybe we should be talking $5,000 instead of $1,500. 5,000. So I'm open for hearing what your resources are, your study shows on that item.
There's no question that many rent-controlled jurisdictions where the ordinance has been adopted, for example, through an initiative, does have the higher relocation benefits, the $7,800 up to $18,000 for the vulnerable tenant. And certainly that kind of distinction could be added to this ordinance.
I would be interested in the vulnerable tenant provision. Otherwise, it just makes it really cheap to come in and flip a unit.
The countervailing thought that I have heard about why that shouldn't be included, the vulnerable tenant situation, is that it might make landlords less reluctant to rent to those tenants in the first place. Leaving aside that that's patently illegal, that doesn't mean that,
we understand
that it wouldn't happen. And so that's
yes.
the countervailing theory.
So one of the provisions that we have put forward for future conversations were tenant incentives, were landlord incentives for accepting certain kinds of tenants. And I think that as we have that conversation move forward, I would prefer to solve that problem with our incentives program that we're discussing in the future than to limit protections in this document. At least that would be I'm one of several people, so we'll see what happens. On page 22, I would love to hear what penalties for violations is typical. It seems to me that if a person commits a first offense, a referral to an education program would be appropriate. Just as if a tenant is causing problems, we would like them to be referred to an education program. We should be referring landlords to an education program. It's not clear to me, is the $250 per unit in the complex? I mean, it says first violation will be $250 for the first offense. Does that include, is this typical? I don't know, so I'm asking you to tell me.
It's typical language in most muni codes in terms of what the penalties for violations are. It isn't totally clear from here whether it's like on a per unit basis or if there's 10 units and the violations that's occurred on all 10, whether that would constitute something greater than one.
Okay.
We can think about how we might want to refine that a little bit if that's a
per
concern.
unit language, if it's clear in an educational program, if that's possible, 3 times and you're a misdemeanor, is that normal?
It is for
It is?
For muni code violations, it is, yes.
Okay. And I've moved on to Exhibit A, which is the capital improvement plan. And I just want to confirm I understand the capital improvement Part C, this is page 2 of Exhibit A, where it talks about the useful life of more than 1 year and under straight-line depreciation provisions of the Internal Revenue Code and the regulations issued pursuant hereto requiring amortization over the useful life of the improvement. This is not my area of expertise. If you can help me, I would appreciate it. Can the property owner essentially double dip here? Can they take this off on their taxes and pass it along to a tenant for cost of the improvement? Is that what we're outlining here, that they can amortize it on their taxes and ask tenants to pay an increase in rent to cover the cost?
I would probably defer to your CPA council member to answer that question, but I think the answer is yes, that if it's an improvement that the IRS allows a property owner to amortize and depreciate over the useful life, that person could do that on the person's tax return, and also they would be able to recover that cost through the formula here from the tenant. So the answer is yes. What we've tried to do here in this policy, though, is rather than get into whether or not the particular improvement has a useful life of 8 years or 20 years or 30 years. We've established simply 15 years as the, in order for the formula to be more simply applied, and recognizing that, some improvements will be more, some will be less, and we've just set a straight 15 years in order to, so it doesn't come as at a big number for the tenant in, like, say, 5 or 6 years.
Okay, I appreciate the second half of that, but have some concern about double dipping. And I thank you again for your patience with me with my questions, and I look forward to hearing public comment.
Thank you, Council. Other questions? Mr. Osaki?
Thank you, Mr. Vice Mayor. Let me start with the depreciation deduction, because it, just to answer my council members' concerns, just to answer my council members' concerns about the double dip, but basically, I don't consider, it's basically the tenant is financing the improvement over time. So I wouldn't necessarily call that a double dip. I do want to, and please correct me if I'm wrong, I thought it was a very concise answer, and I appreciate it. The definition in the ordinance of a capital improvement does not relate to the calculation of the additional rent of the capital improvement. As our city attorney said, it's over 15 years. And we could adjust that to say 20 years, should we decide. So that would be a 5% straight line return as opposed to 15. Or we could go to 10 years. That is.
Do you have a recommendation?
I will. Let's hear from the public. Going back to the ordinance under, and I apologize, I will try not to be redundant in some of the questions already asked. I think I will have caught them all. The ordinance section 6-90.015 under definitions, capital improvement plan. It is just a capital improvement, it is just a definition, but the compliance with the order for a regulatory agency, I'm concerned that owners that have let their property slip that now have to bring it up to code are going to get a higher rent because of that. And perhaps that goes to the calculation in the policy section. But I would like to make it clear, I personally don't feel that's good public policy. If, for instance, our building code inspectors say that there are rodents and mold in this apartment building, it's going to require extensive improvements, I don't think the tenant should have to pay for that. So that's my policy statement on that. So this is strictly a definition in terms of what a capital improvement is, and it's not guidance as to what the calculation of rent increase. Is that correct?
Correct. I mean, that section, that subsection B, could be eliminated as a grounds for qualifying for the capital improvement plan.
Okay, and that would be a way of, and it wouldn't. No, that's a very succinct way to do it. I think I like it. Okay, thank you. If you would make a note of that so we can discuss it as a council, I'd appreciate that. Habitually late isn't defined in this section of the definitions, but it's referred to later in section 125, and it's on page 12, I believe. 5 months of late payment of more than 10 days and 5 return checks within a year period. So potentially a tenant could be 10 times out of 12 late? Or shall we say 9 and not be habitually late? That seems like a high bar.
Can you cite that page number again?
It's on page 17 of the ordinance.
Thank you.
In section 69125B.
I think that there was a problem with just the way that sentence was written, because it says respectively, and I think it means either or.
And I appreciate that. I would like clarification.
I think the and in that last part probably should have been or in looking at it.
Okay, good, because that's, appreciate that. Owner occupied is not defined as well, and also on page 17 of 24, once I can get there, once my computer boots back up again, here we go. I'm concerned, the concern was raised earlier about the triplex owner occupied where it could be a resident manager, and I feel that's inappropriate. So I'd like to, if council so desires, I'd like us to consider revising that, because that basically just if a resident manager can move in and be called an owner occupied, that's not the spirit of what I intended. S- 18 of 24, sorry. G on that page, or for a resident manager. I think we should be, at least as regards to triplexes, owner-occupied triplexes. Again, that's a policy consideration, correct?
Yes, although, again, the resident manager would apply to more than just the triplexes as written. If you had a 10-unit building, a resident manager could move into one of the units, and that would be considered an owner or relative move-in as drafted.
I appreciate that. Do we know what state law is requiring resident managers? How many unit buildings? Is it 15? Do you have an idea what there is a requirement?
I don't know that, sir.
Well, I do feel it's a good, on a multi-unit property to have it's a good policy to have a resident manager, depending on the number. Go ahead.
Does this allow, if a particular rental unit, say there's 15 of them, and unit 1 has been the owner, the residence unit, the resident manager's unit, does this allow the resident manager to move into any other unit?
I think, I'm looking here, I think that there is a, under G2, that,
18, page 18.
yeah, page 18, under G2 there, that if there's a vacant rental unit on the property, no, I'm sorry. I thought there was a section, and I'm not finding here immediately, that if the unit has already been occupied, by an owner, that you only get one bite of the apple, but I'm not seeing that immediately, so let me look a little more closely at subsection G on that.
Thank you.
I do have a question on section 2, though, that the no action to terminate a tenancy based on an owner move-in may take place if there is a vacant rental unit on the property and the vacant rental unit is comparable in size and amenities to the rental unit for which the action to terminate the tenancy is sought. In my mind, the landlord should be able, or the owner should be able to decide which unit they prefer to occupy in their building, as long as their tenant doesn't lose their tenancy in that building of a comparable unit. That's a policy consideration, but they should decide what unit they want if they're similar. Section 90.045, I believe that's 8, it might be 9. Now I lost my spot.
On 045,
045, thank you.
having to do with pets, perhaps?
Thank you, sir. As we discussed earlier, when a change of the, when the conditions are changed, we don't have a provision in here, should an owner, a landlord decide that a longtime tenant has had a pet and changes their policy for that there's no pets, should that be part of this document, that a pet should be allowed, and should the landlord not be allowed to change that policy? They're already going to pay a higher deposit, I assume, and higher monthly rent. I would not want that to see it be a change in condition. since, again, that's a policy.
Can I understand what I'm just asking a clarifying question. If the policy has been to allow pets, a unit with an existing pet is in some way allowed to continue after the policy changes until that tenant chooses to not have a pet?
Well, yeah, I think it should be spelled out for the protection of that tenant.
Okay, I'm just clarifying that.
Thank you. And okay, that's good. And then on the penalties on page 22, I do agree with my colleague's suggestion for the first violation to be a referral. I'm not so quick to jump on just a one-year term. If you've had 2, 3, or 4 violations over 2 years, to me, you're starting to become a bad actor. So I think maybe that 1 year could be, and that's, again, that's a policy consideration, could be increased to 2 years. And then lastly, on Exhibit A, which is the policy document, page 2 of 4, oops, that's the resolution. I mean, let's back up on page 1. Calculation of rent increases. Why do we have an interest rate included in this calculation? Bottom of page 1, number 5.
As opposed to having the interest rate be whatever the interest rate actually is that the landlord would acquire, or just including it generally?
Well, just using round numbers, there's a $15,000 capital improvement over 15 years. Why not give them an annual increase of $1,000 as opposed to putting interest on top of it?
I believe the reason to do that is because the cost to borrow the money, the interest would seem to be a cost of the improvements itself, and therefore it seems logical that the owner should be able to recover that over the amortization period. I have seen, rather than having a formula such as the 1% over the Wall Street Journal's prime rate number, it could read whatever the actual interest rate that the person obtains. The thought that I had here was that this was a straightforward kind of thing that everyone could look at rather than worry about whether the person got a 1% or a 20%.
No, and I agree with that philosophy. If we're going for an interest rate, what if the owner paid cash?
Again, even though the person has paid cash, that money is out of that person's pocket, and shouldn't there be a return on that? That's, the policy call on the council's part.
Understood. So perhaps it might be the savings account rate, which is what, 0.25%. But point well taken. Page 2 of 4, number 6. I think we should add the term base monthly rent. We've discussed that. It just says base rent.
Are we on the capital improvement policy again?
Yes, we are.
And I'm sorry.
Major long-term improvement or repairs. Third line. Shall qualify for an adjustment of the base rent. Shouldn't it be the base monthly rent? It's just a semantic point. I just want to tighten it up. And then number 6, 6A6, the installation of water constellation devices. Should those, it's not discussed that if those reduce operating expenses for the tenant, would it be too onerous to allow the landlord to recoup their investment, the property owner to recoup their investment quicker? I'm just looking at staff time. Say there's less electricity that the tenant has to pay for, less water. Can that be added to the rent?
Certainly, we can, if the council would like to see that particular improvement have a shorter amortization period, certainly can be written that way.
I just want to provide an incentive for those public policy considerations. Thank you for your work on this. I know it wasn't easy, and staff appreciate it.
Mr. Corsi.
Thanks. A lot of my questions have been asked. And I also want to start by thanking everybody for the work on this. I know that it's been a difficult time of transition of staff at several levels. And I appreciate what's gone into this to this point. My questions may jump around a little bit, but I want to start by asking on the capital improvement plan, where did the number of eight times the amount of monthly rent multiplied by units come from? What's the basis?
That seems to be the number that appears in a number of different rent control ordinances that deal with substantial rehabilitation and capital improvement plans in reaching a sufficient threshold so that it's worthy of an amortization as opposed to a more routine repair. There isn't anything magical about it. It could be any number that the council chooses as long as it's reasonable. If 8 seems too high or too low, it could be adjusted. It's simply what I have seen in other jurisdictions, but there isn't anything constitutionally mandated about the 8, for example.
Okay, and as we discussed earlier, there is a provision for improvements that don't meet that threshold for the program administrator to actually make a ruling on at that point.
That is correct.
Now, my understanding on the amortization of capital improvements, we're talking about 15 years, it could be a different number, but the intent of that is to recover the cost of the improvements.
That is correct.
What happens after 15 years? If the monthly rent has gone up $10 a month, say, for all these units for 15 years, the cost is recovered after 15 years. Does that $10 go away?
As drafted, the answer is no.
Why not?
I believe the answer there is because the improvement has run its useful life. Presumably, the landlord would need to go out and make a further improvement, presumably, and therefore the thought that that would occur, it would seem perhaps punitive to reduce the rent back to where it was 15 years ago, and it should be a going forward process rather than a looking backward process.
I don't want to get argumentative here, but if the improvement is paid for, it's no longer useful, and the landlord needs to do it again, the tenant is going to be asked to pay for that again. But instead of paying $10 a month, he's now paying $20 a month for the same improvement. So I think it's something that we ought to look at. No, it's in the amortization discussion. In the definition 6-90.015 in E, it seems that the capital improvement plan, one of the requirements for doing a capital improvement plan is number 3, the implementation of which may render one or more units uninhabitable. We've talked about painting and siding being possible capital improvements. I don't think that necessarily requires one of the units to be uninhabitable. So it seems that the way this is written, that is a requirement.
I think that's why the word may shows up there. That was the intent, so that it wouldn't be required that one or more of the rental units be uninhabitable, it's simply that it may.
Okay. Going to 90.030 on page 7. In A, this allows paragraphs 2, 3, and 4 to be satisfied by referring to a website. I would prefer that this information is given to tenants in writing all the time. On page 8, 90.040, it was discussed about agreements between landlords and tenants. I don't think it's a good idea to allow private agreements to circumvent this ordinance. On 90.045, when we're talking about revising what's included in the rent, I think we should have language about the landlord providing documentation for what those expenses are, such as utilities. Make a suggestion on 90.125, paragraph G, where Mr. Wysocki was talking about the owner or relative move-in, if we had just had some language there about this does not apply to triplexes as far as resident managers, might be helpful. .130. I also have a problem with the relocation fee being set as the monthly rent that's being paid at the existing time. The relocated tenants are going out into a market that is not equal to the market that they're being relocated from. Capping this at 2 months for somebody who may have lived in an apartment for 30 years, I think is unfair. I'd like to take a look at that cap. And I think we should also look at setting the relocation fee along the lines of the average rent in Santa Rosa for that type of, say, a 2-bedroom apartment at the time, plus a security deposit. Paragraph C on that same page 20 also talks about private agreements between landlords and tenants, and again, I don't think that's a good idea. There was a question, I believe it was in the staff report, about whether landlords and tenants should have some skin in the game in hearing costs, 10% for landlords, 5% for tenants. I do think that's a good idea.
Where were you with that, Councilman? What section?
It's in the staff report, and I just have it written down. I don't have the page.
Thank you, I'll find it.
Yeah, I think that comes up in context of establishing what the program fee would be, and the thought was that with respect to the petitions that must be filed for a hearing with the hearing officer, there's an estimated cost for that hearing, and the proposal, at least on a preliminary basis, would be to require the landlord to pay only 10% of that and the tenant to pay 5%. Once you then, at the end of your first fiscal year, when you know more about how many hearings you have, you could then decide whether or not to fold that delta into the program fee overall, rather than have the, so that it would be fully funded. But not knowing the number of petitions you're going to get initially, there ought to be some skin in the game, as it were, in terms of what the cost would be to file a petition.
May I ask?
And the cost would be on the person that initiates the hearing. So if a landlord initiated it, it would be on the landlord only, as I understand it. If the tenant initiates it, it's on the tenant.
Correct.
I'm 5% of the total cost of the hearing. Is that what I'm understanding is the tenant's obligation? Is there any proposal or possibility of a waiver for financial difficulty? Is there any, some of our tenants are, I mean, $5 is a lot for some of the tenants I'm hearing from. So I'm trying to sort out what 5% will mean to them and if that will make them not able to enforce their rights.
Mr. Boshin perhaps can,
Yeah, sure. Just to clarify the situation, there's nothing in the ordinance relative to that provision. That was just mentioned in the agenda report that if the city council was looking for potentially a way to recover costs of the program other than just the program fee, this was an option that it could look at. So if the council would indicate that it has some interest in this option, we can look at it, but it's not currently part of the program.
Remember, there was a range that we're in a conversation about. So, you know, this would be one way. Again, it could be skin in the game. It could help us measure, keep frivolousness out. There are lots of things. There would have to be eventual follow-up conversations like the council member raised around would there be exceptions and what would be the requirement for such said exception.
So we could understand that better in the future. It's not part of this ordinance.
It is not part of the ordinance as it stands right now.
Okay, because I do understand the point you're making about skin in the game, and I understand that. I just want to make sure it's fair. I know that you do too.
Thank you. On capital improvements involving water and energy efficient devices, I'm hoping that we'll take into account the credits that are available to landowners, property owners who install such devices, and that is not, it's taken into account in the cost and reduced, the cost is reduced by those credits. Question that has been dogging, I think, several of us for a couple weeks is about the possibility of a landlord demolishing an existing apartment complex and rebuilding it as a new market rate, not subject to rent control apartment complex. And if this ordinance allows such a thing to happen, and other than relocation fees, what the consequences might be.
The ordinance does not specifically address that issue, and it's a good one that the council members have brought up, because I think if that's a concern, and it sounds like it is, then it needs to be addressed in either in the ordinance or perhaps more specifically in the capital improvement policy, because it would seem to me, by definition, that's going to be a major improvement if the property is going to be demolished and then rebuilt as a rental unit. I would think that by doing it, putting it in the capital improvement policy, that then the new rent could be calculated the same as any other major improvements that would have been done to a property that wasn't completely demolished. I think that would work out in terms of a fair return for the property owner, yet not necessarily cause the rents to go to, automatically to market. Might have to sort of play out how that would work, but I think that would be it would be equivalent to making major improvements to property and letting the landlord get a fair return on investment through the formula under that policy.
If I was a landlord, though, I would probably be making an argument based on Costa-Hawkins that this is new construction.
And that may be a good argument.
Okay, to be continued. Those are all my questions for right now. Thank you.
Thank you. And I'll be brief here. And I really do appreciate everyone in the audience, their patience, because I think we're about to get to public comments here. So I really appreciate, I think the city manager mentioned the bright line, because some of my questions are just about some of the numbers that are here and clarification. So in the analysis of the staff report here, it indicates that 11,000 of the 41,000 rental units would be subject to the ordinance. And then the next item that we may or may not address, 13.2, it identifies, it says there are potentially 13,386 units subject to rent stabilization. Could you share with me, did I get those numbers wrong? Or clarify what are the number of units subject to this ordinance?
The number of 11,076 is the current estimate of the number of units that would be subject to the ordinance that was refined since the first reading of the just cause for eviction ordinance of a few weeks ago.
So with the information that you have now, it's 11,000, not the 13,000
So
that's in
yes,
13.2.
the 13.2, if you recollect, Councilmember, is and to be fair to the team moving at a high rate of speed, that is a antecedent, that comes from prior knowledge. Now that we've refined the work, that's the new number, the 11,000 number is the number.
All right, thank you for that clarification.
Yeah. And I would just add, Vice Mayor, that these are still estimates. One of our first tasks is to get a solid database, addresses, maps of the subject units.
And I'll have some questions on that too. But next question is for Mr. Roush, because some of your colleagues have said with your experience around the state, I'm interested in hearing how other communities have established the rent increase, because in my research I've seen 3%, 5%, 8%, and I'm not sure the methodology other communities have used to come up with that number. Could you enlighten us a little?
There's been a range of ways that cities have done it. In Alameda, for example, the council adopted a 5% rent increase. The process in Alameda is a little different than what this ordinance proposes, because the idea was that by keeping the rent increases, requiring landlords to file something with the program administrator above 5% would perhaps persuade landlords not to increase the rents above 5%, thinking they could live with a 5% rent increase and therefore keep any rent increase out of the hands of a program administrator or potentially a hearing officer. Another example might be that some cities have adopted, again, typically through an initiative process, a CPI or a percentage of CPI. Typically, those are lower than cities that have adopted it by a city council. San Jose, for example, has had in place for many years 8%. That was adopted, however, back in the early 1980s when inflation was very, very high. I know that council has looked at revising that number lower, but I don't know whether or not that has actually occurred. I think the bottom line is that each council has to decide what it feels is reasonable to allow a landlord to get as a matter of right before the landlord has to take an extra step in order to recover or in order to get a rent increase above a certain percentage. Again, as long as there's a process in your ordinance that would allow a landlord to get a rent increase above whatever threshold you establish, then the constitutional requirements are met, that there's a process for the landlord to get a fair return on investment if he or she thinks that whatever percentage the council has adopted is not a reasonable return on the investment.
Great, thank you. I also have some questions regarding the vacancy factor. And in the staff report on page 10, it says currently the residential vacancy rate is substantially below 5%. When staff determines based on a number of factors that the vacancy rate for a 12-month period is greater than 5%, then it goes on to come back to council. What are those number of factors that staff would be factoring in before it would generate it coming back to council?
I think one of the primary issues was the vacancy rate, and then also looking at various policies or goals that the city may have relative to its general plan policies, and also regional obligations as well, particularly RENA, is it meeting the RENA, so on and so forth.
Would the plan be to actually delineate that once an ordinance comes out there so that everyone would understand, here's what the ordinance, and I recognize the council can decide it at any point, we're going to bring it back, but from a staff
I
perspective.
think from a staff perspective, the idea was that we would be looking at an annual report out, because that was one of the questions that had been asked early on of the staff. And then over a 12-month period, if we saw a sustained number that called the question, understanding there might be a variety of reasons that the council may want us to look at it, we would bring this back for consultation. So there is some ambiguity here, but I think the ambiguity was that there are many factors. We couldn't find a bright line because there could be decisions made in arena numbers. There could be a whole series of things. It was difficult for staff to establish the bright line of 5% and all of a sudden the ordinance disappears. We believe that we need to bring it back to have a consultation with council and say, is this reaching a number where council would want us to reopen and relook at this particular ordinance? So we established an annual commitment and then a 12-month period that would have a vacancy rate over 5%. But we would obviously always be coming back with a series of factors you may want to take in consideration as you looked at the rent control ordinance.
And so I know I had asked this of the recently retired assistant city manager. When was the last time Santa Rosa had a 5% vacancy rate?
Do you have the number on hand? We have the number. I will call it up there. I believe it was in the 2000s, the mid 2000s, but we have that number and we will supply that to council.
Thank you. And then in the staff report, we talked earlier about the program administrator. It indicates that it would be the Director of Housing and Community Services. Is that what the plan would be? And is that the cost factor that was factored in?
Yes.
And so it's anticipated that the Director of Housing and Community Services, 20% of the director's time would be focused as the program administrator?
Yes.
Okay. And then we had talked about the relocation costs. Are there any HUD guidelines for relocation costs?
There are for public housing projects.
Go ahead, Steve.
I just know that if it's a public housing project, there are relocation, both relative to the permanent relocation and a temporary relocation. I can't recall exactly what those are at this point, but there are guidelines.
I guess I'm just asking the question. We've had some dialogue about how do we come up with 2 months plus $1,500. You know, if there are some other federal guidelines that give an outline, here's how you might factor that in. I just thought it might be helpful information to maybe look into whatever we want to incorporate here. All right, thank you. Council, are there any other questions? We'll start with public comment. Thank you. Okay, our first for public comment, Ronit Rubinoff.
Good evening. First, I would like to thank city staff for toiling away on this ordinance. This is not an easy thing to craft, and we certainly appreciate also all the work that's gone into it. Just a couple of brief comments. We fully support equity throughout the administrative process that's outlined in the ordinance, so the comments that have been made about equalizing the process for hearing, review, and petitions and participation in that process between landlords and tenants, we think is very important. You need to have due process throughout this. Secondly, with respect to the references to agreements between landlords and tenants, just echoing that we think that that would be evisceration of the ordinance if we allow landlords to try to negotiate their way out of it. Again, the analogy being we don't allow employers to negotiate with employees out of overtime or any other protection under that law. The reason we need this protection is because of the imbalance in power in the marketplace right now. That is why we need the law in the first place. To reiterate that in a different way, right now, the climate of fear among the tenants that we're serving is tremendous. Even given the current moratorium, we are having trouble getting tenants to assert their right to that 3% cap. So putting that agreement piece in there would only further eviscerate their rights. Regarding regarding relocation benefits, I think we need to look not at HUD standards, but our local marketplace, because when we look at HUD standards for other purposes and look at California, we're talking apples and oranges in terms of actual cost. So with respect, I think we really need to look at local economics in that. Right now, a first and last month's deposit for a tenant, which is standard in terms of moving out costs, as well as the multiple application fees that we can anticipate any tenant having to put in to relocate, is going to run a minimum of $7,000. I mean, we know that we deal with these relocation issues every day in our office. So tenants are having a really hard time coming up with the funds they need between those two factors alone. One final comment with respect to duplexes. We certainly understand the philosophy behind excluding a single duplex on a private piece of property, because that looks more like an owner-occupied kind of scenario. However, there are many circumstances where there is actually an apartment complex that's composed of multiple duplexes, and although those are duplexes, really, they're apartment complexes. It just happens to be constructed a little bit differently. So we might request that that exception be noted in the ordinance. Thank you so much for your time and effort.
Thank you. Diane Darrow, followed by Mallory Spilker.
First of all, I'd like to say I'm really angry at all of you. The scales of justice are supposed to be balanced. My crime is I'm a landlord. Where's my representation here? I've been a renter most of my life, and it wasn't until the last 10 years that I've been a landlord. I have never raised the rent on my tenants. When people have trouble paying rent, I don't charge them late fees because I know they're having trouble. Well, then I get the tenant from hell, and you guys are protecting him. He's allowed loopholes. He's been in my house for 11 months. He's destroyed it. I've been in every court possible. I've been in federal court with Judge William Alsop, and it was a frivolous lawsuit. He dismissed it. And you're doing as much as you can to create havoc for landlords. Where's the justice? Are any of you landlords? Tenants have rights, landlords have rights. I'd like to see you all voted out, all of you. Can you answer me? Where's my rights? I started a group called Landlords Fight Back. In 1 week, I got 30 people, 32 people now. We're tired of this. Why are we the enemy? I feel like a Negro in the 40s. I want justice for us. Just treat us fairly. Thank you for nothing.
Thank you. Mallory Spilker, followed by Ann Seeley.
Good evening. Mallory Spilker with the California Apartment Association. The California Apartment Association, or CAA as I'll refer to us, is firmly opposed to rent control and would like to reiterate that rent control policies do not reduce the cost of housing, do not make housing more affordable, and will not do anything to encourage more housing construction or development in Santa Rosa. Despite this opposition, our association vocalized our willingness to work with the City of Santa Rosa on an ordinance ensuring perspective was received from Santa Rosa's housing providers. The rent control and just cause eviction ordinances were developed without any outreach, engagement, or consultation from Santa Rosa housing providers. There was also no analysis provided as to how this ordinance will help tenants, nor was there any analysis as to how this ordinance will impact rental housing providers. Excuse me. Additionally, the retroactive provisions of the rent control ordinance pertaining to rolling back rents to January of 2016 are legally questionable. Seeing as there was zero opportunity for stakeholder input from our industry, we feel strongly that this ordinance is not ready, and we have submitted our suggested amendments in writing to the members of council. This ordinance is punitive in nature for rental housing providers and is as far from soft rent stabilization as one can get. We hope you will consider our perspective today as the industry who provides housing to Santa Rosa residents and as the industry who will be most impacted by your decisions. Thank you.
Thank you. Ian Seeley, followed by Pauline Laurent.
Good evening, Council. Ann Seeley, speaking for Concerned Citizens for Santa Rosa. I commend the proposal that's been presented to you by the staff. They clearly have been interested in representing all parties, tenants, landlords, and in general, the general benefit of public health and welfare. There are loads of things that need to be worked out in this, and then you've had a robust discussion. I know Mr. DeWitt doesn't like the word robust, but I do. Discussion right here, and it's going to get all figured out. So I just want to let you know that I have great confidence that you are going to work this all out, and I want to commend the council for dealing with the realities of the people you represent today. Thank you.
Thank you. Pauline, followed by Beth Streets.
I want to begin by thanking the City Council for all the hard work you've done to represent all the populations in Santa Rosa. I'm one of the vulnerable members of Santa Rosa. I'm 70 years old. I've been in Santa Rosa 30 years. My family, my community, my network of healthcare providers are here. I have been faced with possibility of leaving Santa Rosa because of the rent increases that have been given to me. In the last 2 years, I've experienced a 31% increase in my rent. That's 2015 and 2016. The rent I'm paying now is over half of my income. I have spoken to the manager of my apartment complex, and I believe I've discovered a loophole. I went to legal aid today and spoke with them. I believe there is a loophole, but without protection for the just cause, I am afraid to speak up for myself. Go to legal aid, get in there and have them represent me. I am afraid I will be evicted without just cause. Then I'll really be in trouble. So thank you for your continued hard work. I encourage you to move through this as quickly as possible, because a lot of people in my position cannot come here and let you know their voice. Thank you.
Thank you. Beth, followed by Steve Elliott. Beth Streets. Beth left. Steve Elliott.
Yes, hello. My name's Steve Elliott, and I'm involved with a rent increase. I've lived in this apartment for 15 years, and I was homeless for 2 years, slept in my car, and I had a middle-class, upper-class upbringing. My father owned a jewelry store, so I didn't even know what the name homeless meant. I'd never been homeless, never knew anybody who had been. And I would recommend to anyone, you know, homeless people sleep outside under a bridge, and there's people there 40, 50, 60 years old. And I would be interested to know how many of you have gone camping in the last 10 years. And in a tent, not in an RV or a motorhome or anything like this. So it's kind of like walk a mile in my shoes. You know, go outside and sleep under a bridge once in a while, and you'll have a much different opinion of homeless. And don't do it in nice clothes. Go down to the Salvation Army and buy old clothes, and don't shave, and don't say anything to anybody, and don't challenge anybody. Just go down there and observe what being homeless is about. And I guess I'm at risk. I didn't know that it was even a consideration. I'm 70 years old, and I face eviction. And it's really an amazing thing. I heard about this just heard it for the first time, about $7,000. Well, I know for one, I'm way below the poverty line. If I didn't have some inherited principal, I wouldn't even be able to make my rent now. I get $560 a month from Social Security. Can anybody live on $560 a month? I call it a apartment complex in Petaluma. And one interesting thing about being poor and homeless is the size of the bedroom. How many of you like to live in I'd like to live and sleep in a queen-size bed. You know what most bedrooms are in poor housing? 12 by 12. If you have a queen-size bed, you can just about walk around it. You don't have room for a dresser. So do you want to sleep the rest of your life alone? Those are the options. You can get a twin bed or a double bed. Have two adults tried sleeping in a double bed lately? Give it a try. And also, one of the most entertaining things when I asked this woman what the square foot size of the second bedroom was, she said, 11 by 5.
Thank you, sir.
That's a closet.
Thank you. Edie Sussman, followed by Davin Cardenas.
Yes, thank you. A couple of comments on some of the portions of the ordinance, and I'm going to skip around, not necessarily go in order. But your 6-90.125C, and most of this has been touched on by the council members and staff, but this section .125C talks about, in essence, excluding fixed-term tenancies from the rent stabilization ordinance. And I don't think that was intended by the council. The only difference between a fixed-term lease and a month-to-month tenancy is when the tenancy ends. On a month-to-month tenancy, it's renewed every month. On a fixed-term tenancy, it would be renewed after the specified date. The real difference between those two types of tenancies is that one requires a notice of termination when the landlord wants someone to leave, and the other doesn't require a notice of termination. The date itself gives that. But under the rent control or rent stabilization ordinance, there is no ending to the tenancy except for specified reasons that fall under the just cause provisions. So if you allow the language in the ordinance the way it's drafted now, you will essentially be excluding tenants who have 3-month, 6-month, 1-year leases, and I don't think that's the intent of the council or the intent of the ordinance. I would also add that if this language stays in, a landlord would simply be able to rent a premises on a fixed-term tenancy and then be able to avoid compliance with the rent control ordinance by saying this is fixed term, I don't have to allow a tenancy to continue. In addition, the other points that I want to raise, the agreements between landlord and tenant outside of going through the program administrator. I agree with comments that have been made that that is not a productive way to deal with the situation. In addition to potential coercive conduct, you're dealing with highly charged emotional stakes and people who don't necessarily have all the information that a program administrator would have. And going through a procedure with the program administrator does not preclude the tenant and landlord from talking about where they are in the process, but allowing a program administrator to ask the questions that are necessary to determine whether an increase above 3% is justified. I also think that the relocation costs are just simply not sufficient. We know that, and if they were sufficient, we'd be looking at rents that wouldn't even require us to have a rent stabilization ordinance. So I think the city needs to look at what the relocation costs are and come up with a higher number.
Thank you.
Thank you.
Davin, followed by Carmelita Torres.
Thank you, Council. My name is Davin Cardenas, and I wanted to really also reiterate what Ronit and Edie had said before, and really appreciate the vigilant eyes of Councilmember Combs, Councilmember Corsi, Councilmember Waisaki. You know, I've heard where Aaron stands, and I support that very much. I would have loved to have heard more from Councilmember Olivares. We didn't hear much, but so I want to reiterate those points and really just heighten the fact that when we're talking about these issues, we're talking about protecting tenants who are, this is kind of the new rising America That's what our economy has brought us to. And so when we talk about tenant protections, this is no small matter. These are actually, this is the rising American electorate, and this is the new America that we're living. So we have to, when we talk about strengthening these protections, it's strengthening the most vulnerable populations and our future, and the future of Santa Rosa in itself. Issues like establishing an independent rent board, extremely critical so that tenants don't have to go into the judicial process, but they have an independent and accessible way to bring these grievances forward. Not allowing, I think like Ronit said, landlords and tenants to actually negotiate the terms of rent increases, incredibly important. And then also when we were talking about relocation fees, thinking about putting those at $7,000, $10,000, just considering first, last month's rents, the deposits that tenants have to put down, that seems fair. $10,000 for me would seem fair in terms of thinking about what a family has to go through when they're relocating themselves. So I just wanted to make those points and really also push for just cause eviction policy for everyone throughout our city so that any tenant has a fighting chance to stand up against unjust evictions. Thank you.
Thank you. Carmelita, followed by Candace Nelson.
And I'll be translating.
Sí, muy buenas tardes. Mi nombre es Carmelita Torres. Tengo 10 años viviendo en una propiedad.
Her name is Carmelita Torres, and she has 10 years living at the property she's at.
Y hace como 3 semanas me llegó una carta donde me dicen que tengo solo 60 días para dejar el apartamento.
And 3 weeks ago, she received a letter saying she had 60 days to evict her apartment.
Sin razón alguna, tan solo por pedir que arreglan cosas descompuestas o que hicieran cambios.
Without any reason given except that I had asked for a couple repairs done to the apartment.
Y pienso que inquilinos como yo o que estén pasando por lo mismo, queremos que haya una ley que nos protejan de la angustia, el dolor y la tristeza de pensar a dónde llevar a nuestros hijos a dormir o a prepararles alimentos o a bañarlos en tan solo 60 días.
So I hope that there is some kind of lay passed to support renters like myself who have to go through the injustice and anguish of having to relocate ourselves or figuring out where we're going to prepare food for our kids or get them ready for school, especially within the time frame of just 60 days looking for a new place.
Gracias.
Thank you.
Thank you. Candace, followed by Dwayne DeWitt.
Hey, everybody. This is my first time speaking in front of the council, so I would like to thank you guys for the opportunity that you give us to do this. I also appreciate the fact that the rent stabilization conversation has actually came this far. The moratorium has helped my family specifically because we would have received a notice that our rent would be going up in November this month. So it's helpful, and I want to say thank you. And hopefully it'll be extended until we figure all of this out. I'd like to thank all of you for putting in the time that you have to just get to this part. I mean, I'm one of those rare people, I understand both sides. My wife and I work for the human services field. So we help adults with disabilities of all different types. They go to a day program. We make $13.45 an hour, and we just got a $1 raise last year. And they made sure that they let us know that it took them a lot to give us that. Over the past 4 years, our rent has gone up about 30%. Now, we have some really great landlords. Over the years, we've been there about 7. They take care of things. They come in, and they make sure everything is fine. So when I had to stare at them from across the room the last time we had all the landlords and the tenants here, it made us a little uncomfortable. So I had to go to them, and I had to tell them that I appreciate the kind of people that they are. But I understand that for the sake of their job, they had to come here and stand up for what they had to do. But for also a year and a half, I had to have a second job just to be able to pay rent. My car is 11 years old. It's new to me, and I'm still making payments on it. We don't have a lot going on. We don't ask for a lot, but yet we still have to visit a food bank to supplement what we eat because things are not cheap here. So I just, my time's running out, and I just want to know how and where can we survive, if the rent keeps going up. I understand that landlords have expenses. We have expenses too. We have to worry about, luckily I don't have kids, but we have to worry about food, rent, shoes, clothes. And we can't afford to buy a property to profit from it. We have to rent. So just please keep that in mind. Thank you.
Thank you. Dwayne DeWitt, followed by Perry Engel.
Hello, my name is Dwayne DeWitt. I wanted to thank you for all your hard work, and especially tonight, the very in-depth and piercing questions that are important to this matter. I want to make sure that you understand it's important not to be swayed by the boogeyman. There's people out there who are going to say, oh, if you have this, things won't work. I've been fortunate in my life that once I had moved around a bit after some military service, I lived in rent control cities, both San Francisco and Berkeley. Functions well, it helps, especially senior citizens and those on limited incomes, disabled. But unfortunately, greed really gets in the way a lot of times, and greed is really playing a part in a lot of cities, and that can ultimately create a lot of difficulties. I faced it here in Santa Rosa during the last 3 years. 3 years ago, I moved in to a rental unit, and the owner was a nice lady, gave me what I thought was high rent at $936 for a one-bedroom. Had to take it, couldn't find anything else because everything in my home neighborhood of Roseland is all packed up. You cannot find units anymore right now. So I got in there. Another person bought the building in less than a year, raised the rent on me 3 times. First time up to $1,100, then up to $1,175, then $1,315, and sold the building. Made $1 million profit on owning the building about a year and walked. The place is in worse shape. We have basically not had real improvements, just some cosmetic, paint something and say, okay, now I can sell it to the new owner. So the new person that's come in has been a nice person, been there about, this is the 4th month since the sale, And they're kind, and we're just waiting for the next rent increase. We've told ones are going to be coming. So I'll be looking elsewhere perhaps. But I don't know if I'll have that opportunity. I looked in the mirror the other day and somebody pointed out that I was aging quickly. I'm soon to be an elder, and that's going to make things more difficult. Anyway, I want you to definitely do the rent stabilization policy, do the utmost that you can to protect the tenants. The owners, they got all kinds of people on their side. They got the Chamber of Commerce, they got the North Bay Realtors Association, they got everybody. They got more money than God. And that's what people are up against when they're just the basic renter and they've gotten their notice and they're going to be gone. It's a difficult time, and you are the people who can help the citizens, the residents, those folks with families. Please do your best to do so, and thank you so much for all your effort that you've given tonight.
Thank you, Dwayne. Perry, followed by Teresa Chavez.
Good evening. Over here. I, like so many of the people that have spoken to you earlier, I'm a retired person. I live with my wife here in Santa Rosa. We moved into an apartment 3 years ago, and we've gone through an experience much like it's been described by so many people. Had you not passed the emergency rent control ordinance that you have in effect, my rent starting September 1st would be 62% higher than the rent I paid in 2013 when I moved in. The place had been sold to a real estate investment trust, and the trust felt that they could just move with the market. So living in a market that has virtually zero inflation, they're just going with supply and demand and boosting. Something happened recently that is why I came here. My landlord is accepting the ordinance, my rent increase dropped to only $118 from some $400 that it was going to be. But immediately after that, I have a ground floor apartment, which has always just had a door that opened into the common area, as we all did. Suddenly, they've come around and put little fences around each apartment's patio door and told us we now have enclosed patios. I see this as coming to you as a capital improvement under your plan, and justifying, therefore, a more substantial rent increase the next time around. I would question the value of the improvement. 3 guys in 3 days, I don't see a lot of investment there. But in any event, I hope that what you finally end up drafting will have the flexibility to prevent what I think might be here an imposition on the intent of the rent control stabilization. One other thing I would like to bring up. There's a real fear amongst many of the residents of our building. Some, like others referred to here, have been there for 30 years or more and are in their 90s, that this building will soon be announced that it's going to be converted to condominiums. I don't know what legal protections or ordinances or rules there are out there concerning such actions. It's hard to tell somebody who owns a piece of property they can't do what they want with it. I understand that. But at the same time, this is 150 units in this particular complex. This would be a noticeable force or change in the force if something happened at Santa Rosa. So thank you very much.
Thank you. Teresa, followed by Thomas Ells.
Can Gervasio read Teresa's statement?
Sure.
Hello, good evening. I want to speak on behalf of Teresa Chavez. She got involved 2 years ago on this fighting organization for the rent stabilization, and her family has seen some benefit, so she wants to share the same for other families or low income. And she's also asked that she got involved when someone tried to raise her rent more than 3%. And so she really got the benefit and all her family, and she wants this for other families who doesn't make much for a living in this county. So she recommends we keep this rent stabilization for everyone. Thank you.
Thank you. Thomas Ells, followed by Wendy Woods.
Thank you so much. Here we are. This is marvelous in its direction and fabulously difficult in its content in some ways, I'm sure. And wonderful that everyone has engaged in it. There's many things that I have to say. Number one, I would say that refurbishing is different from rehabilitation. And so refurbishing is sort of a polishing of something, and rehabilitation extends the life. It has to materially extend the life. Deferred maintenance is not a capital improvement, and there's no part of deferred maintenance that's capital improvement. That often is confused. Appraisals will look and state both those parts. One is deferred maintenance. Those aspects would reduce the value from the market value. So that should be applied to the person who is buying a potential property. He should know that. He would know there's $1 million of deferred maintenance on this $12 million property. It would be worth $12 million except for the $1 million of deferred maintenance, and the price should be $11 million. So he should only pay $11 million. He shouldn't pay $12 million. And any adjustments in expectation of rising rents, well, they should seriously look at this, and obviously you're going to have notification. But all of those things would be taken care of in the appraisals, and they would have rent studies, and they would know all those. Relocation bonuses, are important, and I noticed that you guys talked about that. So state law allows for sequestration of rents and rental and tenant relocations. It's really important to follow state law on that. It's very broad, but it's part of the inspection and the whole process that you're going to begin with the program administrator and so on. Very important, but we need to understand that state law allows for sequestration of the rents and the relocation of the tenants and their further reoccupation of the property. So it's very important. Relocation assistance, except when the tenant files with the program administrator request or a petition or a hearing. So there's part of the wording in here that doesn't always work. For instance, 6-90.155, there's not the opportunity for specific performance and the right to reoccupy the property under the injunctive relief. So you want to have, if you go for injunctive relief, you want to be able to specifically have specific performance under this ordinance and the right to reoccupy the property. Under 60-90-125K, to comply with state law and sequestration again of rents and relocation rights in the rentals and so on. So
Thank you, Thomas. Wendy, followed by Josh Katz.
I would hope that we could have further, I hope this is.
Wendy, go ahead.
Hi, I just wanted to share with you my own experience with the ordinance. I've lived in the same apartment complex for 15 years. And about 3 years ago, there was a new property management company that came in, and the rents immediately began to rise significantly. It was difficult seeing a lot of my neighbors being evicted and people I've known for a long time. I've since seen some of them on the street, and so that was hard too. After this ordinance started to gain motion, before it became the ordinance that it is today, a lot of the activity with rent increases in my complex ceased. And that was for a certain length of time. I was wondering what was happening. Well, it turned out that it was because this ordinance was happening. And then the property manager came around with notices just before the vote was taken here on the ordinance. And they said, well, we're going to give you one big increase now because we believe this ordinance will go into effect. And they did, but it turns out we didn't have to pay it. They retracted it. And I thank you all so much for that. It's made a huge difference in my life. So let's see. The other thing I just want to mention is that I do work as a process server, and so I serve eviction papers a lot of the time. And while I realize that landlords are treated unfairly by tenants, I think from what I see in the paperwork anyway, it's much more often the other way around. So I'm thankful that this ordinance is in place and that tenants will have a few more protections. I also hope that landlords have opportunities that they didn't have previously to protect themselves with the process. Okay, that's it.
Thank you. Josh, followed by Steve Bertelbaugh.
Thank you. My name is Josh Katz. I'm an attorney here in Santa Rosa. Much of my practice deals with housing issues. I've read the proposed ordinance and listened to everything. I'm going to try to not repeat what people have said. In section 040, I think it would be a bad idea to allow tenants to waive the protections they've just been given. In other important areas of housing law, that's not allowed, such as habitability. You can't waive the habitability requirements under state law. And I think what would happen was you would end up with the people most subject to coercion would be the people who most need the protection. And so it seems like, again, like a loophole you'd be able to drive a truck through. Under .075, again, I don't think there needs to be a limitation on the time when breaches can be raised. most typically, I think now the current time says 30 days. It's probably unlikely that people would necessarily recognize the breach within 30 days. The law provides for statutes of limitations for any sort of breach of contract. If an amount that was collected was inappropriate, same way if you were making payments on a car loan and you found out you had paid too much, you've got a statute of limitations period for the breach of contract where you can go back. I don't think you need to provide that sort of artificial limitation here. One thing that was raised, I believe, by Councilmember Combs early on had to do with the notice that would be provided regarding any of the petition or an appeal or any of those procedures. My suggestion would be, and I'm not sure if this is in there, but that any time a petition or an appeal is filed, any sort of proceeding is initiated, it would make sense for the administrator to send out to interested people some sort of general notice, whether it was initiated by a tenant or by a landlord, something to everyone involved saying this procedure or proceeding has been started, and here's how you participate, and here's how you get more information. With respect to .80E, the fixed term lease, I don't know whether that was intended as an out, but it will quickly swallow anything that you've done here today. Most leases, in my experience, start with a fixed term. And if they don't now, they certainly will. If you pass some sort of rent stabilization with an exception for a fixed term lease, every lease is going to be a fixed term, and you're going to have massive turnover at the 1 year point so that people avoid that restriction. And it's going to be worse than, I think, if nothing were done. One final thing is I think you need just cause across the city because we are largely now a community of renters. And that's the only way to provide the stability that people need. Again, most importantly for children who are going to school, for seniors, for disabled people, but really for all people, you need the just cause eviction.
Thank you. Steve, followed by Darrell Paul.
Thank you, Vice Mayor and members. Steve Bertelbaugh with the Transportation Land Use Coalition. I'd like to focus on two areas. One is the recommendations that you've gotten from the two lawyers here. I agree with them. The other is the sense of community that's created and would be destroyed or is destroyed as you have turnover. We're in a crisis now. We're in a housing crisis. The importance of this is that it will dampen down the greed factor and permit people to expect that they're going to stay in place over time. When you raise rents at high rates, you lose the sense of neighborliness, the things that knit a community together, and the neighborhood tends to go downhill. I think landlords ought to be worried about that. So it's a benefit to the entire city, what you're doing, and I really compliment you for taking it on. Thank you.
Thank you. Darrell?
Good evening, council members. Thank you. The last time I spoke before City Council was many years ago when the discussion was about the bridge over Spring Lake for Highway 12. So it's been a while since I've been here. My concern, interest regarding rent and rent control and cost, I've lived here many years, and I don't see a lot of help for veteran assistance. You know, I was in the Navy from 69 to 73, and it'd be really good if there was some type of, you know, assistance to help veterans out. You know, yes, there's veterans organizations, but I mean something possibly written into, you know, city ordinance. I don't know. I've had been paying rent since I've lived here, different locations. The last house I lived in, I was there for 14 years. 12 of those years was $1,400. The last couple of years, it was $1,650. I couldn't afford it. I looked for a place to move to. Came close to buying, great credit, but didn't, you know, had a down payment, but wasn't enough. to buy a mobile home. So I kind of lucked out at the last minute and found a mobile home that is within my price range. So I just thought I would mention this, and I thank you all for your time.
Thank you. Peter Chernoff, followed by Daniel Sanchez.
Oh, yeah. Good afternoon. Rent control. The promised land she be my goal. How long ago regarding the status quo? For greedy monies, they sold their soul. Well, there are 2 million vets, and they are ready, I warn you. 2 million abused vets just here in California. They need but stand and the game is over. And what if these 2 million vets got together with the farm workers, the ones that are feeding a lot of them? And what if we remember Green Acres? I loved that guy. He was a lawyer, but he quit being a lawyer so he became a farmer. And where are we but California, in the land of Luther Burbank, the most beautiful place in the world to grow veggies and fruits? And Cactus Pete says if we do it the right way, we end all disputes. Now, all you people asking for help from this council in front of us know that I have said before they could do so much more if you would allow them to do more. See, they work for the system. 40-day huelga la general, and they work for you. Get off the fence. Stop paying the mortgages and rents. What do you think would happen if when or as all the vets and all the farm workers and the migrantes and the seniors and those of us who have hearts and are tired of serving the bankers and their minions of lawyers say enough is enough? We give you not one more penny. The very same people that can't do for you right now, they will do nothing either when you all stop paying all this rents, these ridiculous rents. Use some common sense. Use your power. Rosebud, rosebud, come now to flower. It's a beautiful time to end all this crime. They would do more for you if they could, but they can't. You're the ones that have all the power. Why do you keep asking your servants to do what you need to do yourselves? Are you so brainwashed to be forever Mammon's elves? The veterans and the farm workers and the students, we all have so much power here in California, but we've been under this veil of illusion of which there's a profusion. Well, it's burning as we speak. Every day and every week, it's a baptism of fire to take you all higher. What is this cluster truck of lawyers you're listening to for your solution? The power be in your heart with the resolution, the 40-day general strike.
Thank you, Peter. Daniel Sanchez.
I'm Daniel Sanchez, North Bay Association of Realtors. I hope that the city continues to include Councilmember Wysocki's previous exclusions to the rent control and just cause eviction ordinance. If you all remember from a couple weeks ago when the just cause eviction ordinance was proposed, you all agreed to have the restrictions that apply to rent control also apply to just cause eviction be those same units, that is, only to Costa-Hawkins eligible units. If that's not the case, then you're going to have this ordinance covering two separate types of rentals. One, single-family homes, duplexes, triplexes, condos, and everything else, and the other one, just Costa-Hawkins eligible apartments. So you'll have a two system of regulations, and that's going to obviously cause confusion. And as I mentioned last time, there's no reason why just cause should be applied to McMansions up in Fountain Grove that would rent for $5,000, $4,000 a month, that where you would need about $15,000 move-in costs initially. That type of unit is to a family making well over 6 figures. That's not the type of unit that would be going to low-income families. The last thing I wanted to point out was the City of Santa Rosa currently gives a 10% grace period for water users that pay 10-day grace period for water users that are 10 days late on paying their water bill. And after those 10 days, they're subject to a 10% fine of that charge that they were supposed to pay. So if you pay your water bill more than 10 days late, you're subject to a 10% fine. That's what you all impose on your ratepayers. I am pretty sure you all would not impose that for your property owners, or you would not allow that for your property owners, yet you allow that, yet you do that for your ratepayers. There's a term when you require people to do something that you yourself don't do. It's called hypocrisy. Thank you.
Thank you, Daniel. Those are all the cards I have for this item. We do have 2 piles of cards for some other items, so if anyone else would like to comment on this item, now would be the time to do it. Seeing no movement, I'll bring it back to council. My thoughts would be if you have any questions of staff, and then we'll entertain a motion, and if we get a second, then we can have discussion. So any questions for staff? All right, Ms. Combs, I think you have this item.
I have the item, and...
Wait, if you could, we have a question for staff.
I do have questions for staff. You have questions? Good.
I'm sorry. Go ahead, Mr. Wasaki.
Thank you. We received a communication today regarding this proposal that says if any rental units, this is under section 690.020, any rental units that are subsidized by a government agency are exempt by the ordinance, and they were concerned that renters receiving Section 8 HUD vouchers would be construed as under this provision, and therefore their units would not be exempt from this. Could I get a response, please?
As drafted, the ordinance would exempt those units that are subject to the Section 8 voucher program. And the rationale for that is that there is a separate regulatory agreement that applies to the rents that can be charged and the eviction procedures that apply, and to if these were not exempt from your ordinance, then you could have the potential for conflicting provisions. Now, in the event that the property owner decides to go out of the Section 8 program and the unit is otherwise subject to the ordinance, it would then become subject to the ordinance, but currently those rental units covered by that program are exempt under the draft ordinance.
Thank you. Does that, and I'm assuming that any Section 8 buildings, their rental increases have not been, in the last 3 years, what we have seen. Do we have any idea as to what those numbers have been, what those percentages have been?
The voucher holders' rent increases have been tracking fair market under a HUD definition. So they're not necessarily exempt, but it allows us as program administrators to only pay up to fair market as defined by HUD.
Thank you. Does this ordinance address condo conversions?
My understanding is that the city has a separate condominium conversion ordinance, and that ordinance, if it's typical of most city condominium conversion ordinance, has its own provisions with respect to what tenants or what persons who live in those apartments that are being converted to condos are entitled to receive. So my sense of it is that those types of evictions, if they exist, would be applicable under your condo conversion ordinance.
Okay. Thank you. Thank you, Mr. Mayor.
Mr. Corsi.
Yeah, a couple of questions. It was suggested that the provision rolling back rents to January 1st of this year is not legal. Can you address that, please?
It is not uncommon in rent control jurisdictions to roll rents back a reasonable period of time in order to address the
the notion that rents have been increasing more than what the council feels is fair in a certain period of time. I have seen ordinance rolled back as far as 2 years, and therefore I did not think there was any difficulty from a legal standpoint to roll the rents back to January 1st, 2016. In addition, of course, the ordinance does provide for a landlord to seek a rent increase above the 3% for the grounds listed in the ordinance. So if there's some concern about not getting a fair return on investment, there's a process to recover that.
Thank you. Also, I believe it's fairly typical for landlords to include in the terms of a lease financial penalties for bounce checks or late payments. Is there anything in this ordinance that would prevent landlords from continuing that type of policy?
There's nothing in the ordinance that addresses that or prohibits it.
Thank you.
Thank you. Back to you, Ms. Combs.
I have the ordinance, and I would like to comment first that in the context, what is the context of this action? This action is in the context of an aggressive housing plan that we are bringing forward. We are bringing forward a Housing for All program, and recognizing the needs of a housing crisis involves taking 3 kinds of actions. That we protect the residents we have here now, that we preserve our existing housing stock, especially our existing affordable housing stock, and that we produce more housing. We have a plan with this to do those 3 things. And I want to be clear that we are talking about this in the context of a plan with all 3 elements. So what we're doing tonight is protecting the people we have living here now, protecting our existing residents and our existing neighbors. We have a plan and are moving forward with actions to preserve and produce housing. So I just want to be clear that we're making this motion in a larger context. As I make the motion, I want to be clear about what we're moving forward with. What I have heard is that we are dropping language with regard to side agreements among landlords and tenants. That we are mirroring due process elements, providing notice to all the parties whenever either the landlord or the tenant makes a provision change. That we're adding that sort of language that was in the tenant's request section to the landlord's request section, so that we're assuring due process for both parties to provide documents, information, to have input to the hearing process. That we are adding to the language, the rights of first refusal for reoccupancy if the unit had to be vacated for repairs. That we are adding the right of first refusal to reoccupy if the tenant had to vacate the unit for capital improvement repairs. Help me if I've missed something. Let me just make sure I have. We have a discussion. 90.030 was a request in A that not just be directed to a website, but include in writing. There was a request at 90.045 that I think this appears to be a kind of pass-through charge, that landlords have to document their actual utility costs with documentation if they're going to pass through utility costs. in .065, improving that notice to include notifying the tenant of their right. Where are we on .075 with terms of the tenant's limitation of time to take an action? We had one public commenter who said this is already an existing law when there is a breach of some kind of contract, that there are terms of limitation, statutes of limitation. Do we have a problem with referencing whatever the existing law is for statute of limitation, as opposed to limiting to 30 days? Okay, I'm looking at my fellow council members. Any issue with that? Okay, let's remove the 30 days and go to whatever the existing law statutes are. We remove .080, item 5. We had a conversation about the historic building designation.
We did not have a conversation about number 3. We had on that same section.
3, 7, and 8 seem to be a package of how do we handle improvements that are not meeting the level of capital improvement plan, and when they are maintenance or not. I am open for language suggestions. I have no problem with accepting capital improvements that haven't made it into a plan, but I do have some concern about maintenance and repair being allowed under this section.
Well, that's my concern with that. We have a definition of a capital improvement plan, and this is allowing
A capital improvement that isn't part of the plan?
Correct. It's in direct opposition to the other clause.
So we've defined capital improvement in such a way that it can't fall under item 3. Is that correct? Have I misunderstood that?
Yeah. The definition of capital improvement under the definition section is an improvement that materially adds value to the property, prolongs the useful life, has a useful life of 1 or more years. Yeah, that's sort of the definition, and then by incorporating that in 3, but unrelated to the capital improvement plan, it means those types of capital improvements that doesn't reach the threshold number. Now, certainly, if that is included, then maybe 7 and or 8 is sort of subsumed within that, and maybe you don't really need 7 and 8 because they do provide some.
Would you accept 3 without 7 and 8?
Well, I'm just thinking whether or not.
I'm asking council members
I'm sorry.
for a policy.
I apologize.
I
It's okay,
can,
appreciate
because when
your
you look
thoughtfulness.
I personally could, because when you look at the whole structure of this clause, the program administrator may take into consideration, so that would be fine.
Would you repeat what's fine?
Strike 3 and keep 7 and 8.
Oh, that's the opposite of what I thought.
Well, I think number 3 is redundant compared to what we've just, the whole definition earlier in the ordinance.
I'm hesitant to allow the reference to maintenance and repairs.
I can go with that.
Where are you? You're with 3? Okay. Would you accept 3 and 7 without 8? Would you accept 7 without 3 and 8?
Slow down.
This is the sausage part?
I'd like to hear from Councilmembers Corsi and any others, Councilmember Carlstrom, perhaps.
Councilmember Corsi, do you have an opinion on .080, items 1 through 8?
Yes, I've said I would keep 3 and delete 7 and 8.
Ms. Carlstrom, Councilmember Carlstrom, do you have an opinion regarding items 1 through 8 on section .080, page 12?
Yeah, frankly, I don't agree with the inclusion of items 3, 7, or 8, but I'm not hearing that the removal of those would get any other support.
You would remove all 3 of them?
I would. I think that the capital improvements unrelated to a capital improvement plan defeat the purpose of the capital improvement plan requirement.
I would agree with that. 3, 7, and 8 being removed.
I think that would be okay because you also have paragraph 10 right now, which is sort of the catch-all that allows the landlord to justify or to come in and argue that it needs a rent increase, whether you specifically 3, 7, or 8 anyway, to get a just and reasonable return on investment. So I think that the language in 10 is broad enough, so if you eliminated 3, 7, and or 8, it's not really going to prevent a landlord from still making that case with the program administrator.
That makes sense to me.
Okay, I will accept the elimination of 3, 7, and 8 in my motion on the assumption that 10 provides broad enough language. And we mentioned the general notice regardless of who made the petition or is filing the petition. We made the statement about not having there be side agreements. The item regarding fixed-term tenancy, I actually have seen this be a problem at manufactured home parks where people who were homeowners were essentially told that they really wanted a lease and they got a fixed-term lease and then they didn't have rent control through the manufactured home park ordinance that we have now. And we have had a number of comments negatively about that in this other rent control ordinance that we have. So I would like to exclude the fixed term section. Essentially, I view failure to renew as equal to an eviction. Is that clear?
Apologize. This is the last part of 125 C on page 17. Is
Yes,
that the
it's
reference?
or if the tenant is holding over.
Right.
Yes, that's the section. I would delete that sentence or that fragment of a sentence.
Got it.
Is that okay?
That works. Did we also fix the language on that same section under B, habitual late payment of rent?
I'm sorry, say that again?
That
Oh, the
same
wor-
section, habitual late payment of rent.
Or, the
It was gonna
introduction
be-
of the word
That's
or
fixed.
instead of and.
Yeah, we'll rephrase that to make it more clear.
Thank you. Where are we on G with regard to the resident manager on page 18? I would have excluded item 4, resident manager, from the list.
Certainly, I agree with you for owner-occupied triplexes.
Okay.
That's,
So is that clear? That it does not, owner-occupied triplexes don't also have a resident manager?
Meaning that a resident manager would be okay for an owner move-in with a fourplex or larger? Okay.
This is including the section about, there was a section that you noted had been left out that I want to make sure goes in.
Yeah, and I really don't see it here, but it could be added. This is basically once the landlord has exercised the right to have a relative move into one of the units, then you don't get another, the landlord does not get...
You don't get multiple bites at this apple?
Yeah.
Okay.
The only question is whether you would want to put some sort of limitation. In other words, it couldn't be done any more than once every X number of years, or just have a blanket, you get one bite and that's it.
At this point, I would go with you get one bite and that's it, and at some point, the program administrator may want to come to us. Okay?
Councilmember Combs, I wondered if you might return to the habitual payment of rent discussion. I had a question about that actually earlier.
Yes, thank you.
There is a bit of a vagueness as it pertains to the phrase within a 12-month period. In other of our discussions, we've kind of bookended that. And so I'm curious if that is rolling, if that's within a calendar period. At what point does the clock start and or stop for payment of rent is more than 10 days late?
If we were to say within any, I'm looking for the language here, I apologize.
It's page 17, B, habitual late payment of rent.
That within any 12-month period? That within any 12-month period of rent?
Do we use
or
the
within
phrase
a
12-month?
consecutive 12-month period?
I guess I would be looking to you for guidance for more clarity, because my concern is that a tenant may go 6 months between having late checks, and they maybe were experiencing a period of unemployment, or they got divorced, or something happened to them, and they're recovering, but yet the landlord could look back and say, yeah, but 7 months ago you had a period of 4 late checks, or whatever it may be.
I'll come up with some language that will clarify that a little more.
Okay, thank you. And is at any point is the landlord's waiver of this perceived habitual lateness addressed? Do we address whether it can be said that a landlord has waived their right to evict a tenant based on this behavior, based on these actions?
The ordinance doesn't address that. Presumably, if the landlord fails to take action, even though he or she could, then a tenant could arguably make an argument that the landlord has waived that in the unlawful detainer action, but the ordinance doesn't really. I mean, we could add some language here. It says that if the landlord fails to take action on this within a certain period of time, the remedy is waived, if that's something the council would want to see added here.
Aren't we
what you're
being
looking for?
inconsistent with the statute?
I am reluctant to add another wrinkle at this late stage. It was just something that had occurred to me. It is a legal remedy available to tenants, but I would certainly hope that we would prevent some of them from finding their way into the unlawful detainer scenario. But I'll withdraw it as a major concern. It was just a point of interest for me.
Okay. If we're still all together, I'm looking at page 19. This was where we allow the right of first refusal regarding capital improvement plan. I think you had some language on that already. And then we get to the relocation fee. I think we requested that you add language regarding vulnerable tenants, particularly seniors, disabled, and persons with children. I believe we added I'm seeking guidance from my fellow council members. It concerns me that it is not a future 2 months rent. It concerns me how we would calculate that. Are we good with going for a set dollar amount, such as $5,000 or $7,000, and not citing the 2 months rent?
I would prefer a set dollar amount. I'm concerned with calling out subsets of our population. I think that they would have a problem getting in the door to be renters in the first place with them having larger relocation fees, and I think that might compound the problem.
Okay, so essentially we're assigning a larger relocation fee to everyone.
Correct.
Okay.
At least that would be my.
And what dollar amount are you thinking at this time based on the likelihood that there will be some conversation about it?
I'll wait to hear.
I'm actually not in favor of a set dollar amount. I'd prefer to see the average monthly rent for a one-bedroom or a two-bedroom or a three-bedroom apartment times at least 2.
Who calculates that?
I think that we have that information, average rents in Santa Rosa.
Would the program administrator be the person who made that determination?
You could make that determination.
Plus a fair security deposit, which may be the same amount as a month's rent.
So it would be essentially 2 times the month's rent based on the market average at the time,
And
as determined by the program administrator?
And is the comparability as to the unit that the tenant was currently in? So if
Yes.
the tenant was in a 2-bedroom, you would
Yes.
do an apples to apples?
Yes.
And with respect to then what are we going to distinguish then between the vulnerable tenant and not, or just have the flat amount?
If we added plus 5,000, I would not distinguish between the two. So that, because the costs of moving and paying fees and deposits is significant.
Plus 5,000.
Right.
To what?
To the 2 months of rent.
And the security
Well,
deposit?
the security deposit I thought was the second month's rent. First month and then the second month. No, just 2 months' rent plus 5. Based on the fact that I'm seeing 7 other places.
I'm not sure I'm going there.
Where are you
I'm
going?
talking about 2 months' rent plus security deposit, so first, last, and deposit.
First, last, plus deposit, and not covering the costs of moving and relocation. I mean, have the truck come out and move you.
I would estimate that's about $6,000 in our current market from what I've been hearing.
That's why I'm at about 5 to 7. I think that the actual cost of moving needs to be included. Do you have an opinion? Have you moved recently?
I certainly, well, not recently, but yeah, I mean, first rent plus, first, last, plus the security deposit on average in Santa Rosa right now is $6,000.
Yeah, and what is moving expenses roughly? Do we have a figure for rough moving expenses?
I mean, that's where I would
two-bedroom?
say you're pegging more towards the 1,500, but I can't come up with a
Where
number
did the
like that.
1,500 come from? It's not in any documents that I've found.
Yeah, it was simply what was adopted in Alameda, and I brought it forward.
Yeah, I know it costs more to move than that in Alameda. Are you only at first, last security deposit and not at the truck to move to? Can you be persuaded to the truck to move to?
I want to hear what Council Member Carlstrom has to say on this.
Sure, peg it on me. 1,500 as a flat fee is insufficient. It doesn't cover anything, frankly. But there is something that rings for me as far as, being a single person with children, that I know they look for that on your application, and I don't want to make it more difficult for people to.
So we would eliminate that one.
No,
okay.
I think that's a vulnerable population. In fact, there was a study that we all got an email earlier from a CAR program talking about how a large portion of people living in poverty in this county are single parents with children, specifically those under the age of 5. So I can't massage a specific number. I'm comfortable with first, last, and a security deposit, but I can't see how we reasonably require the moving costs in any predictable way in an ordinance like this.
Well, if I may add, then you have to just put a number and just hope for the best if you can't predict the moving costs, or just not consider them.
Well, is that where we're at? We're either picking a number or eliminating them.
I think that's where we're at.
Well, so if we're talking first, last, and a security plus moving costs, we're talking about $7,500, generally speaking.
First, last, security deposit plus $7,500?
No, plus the cost of moving it that I've estimated at $1,500.
So you think $1,500 is the cost of moving? So first,
So just-
last,
so,
security deposit?
So just add the security deposit and we've got your language. Because it
Right,
has first.
Okay, so first, last, security deposit plus the $1,500 as it shows here?
I'd go
Do
with
we
that.
think that's sufficient? Okay, I hope that at some point the program administrator will come back with more facts. But I'm willing to go forward with a guess and to do some iterative processes.
So was that 3 months rent?
First, last month's rent, plus a third month's rent as security deposit.
That's what I'm just trying to.
Yes, I'm
make a-
clarifying.
And
Plus 1,500.
And to further clarify, it's the average rent for the bedroom size times 3 months then?
Yes,
First,
it is.
last deposit, plus $1,500.
Yes. And that it changes based on CPI. And, you know, we understand that this is a process, and we will do our best to move this process forward as accurately as we can. And we understand that we will be making modifications and revisions as the program is operating, and we find where we need to do changes and make things that are more necessary. Are you okay?
Just want to point out that the suggested relocation fee was based on 1 or 2 years residence. And if it was 1 year or less, it was 1 month. And if it was more than 1 year, it was 2 months. And do we want to have that kind of scaling of this, or is it everybody gets the same? Raise that question to my colleagues.
I would have treated everyone the same.
I'm okay with it being the same because it is the property owner initiating the action.
Yeah. If you've just saved your savings and moved, you don't have it to move again? Yeah. Okay. I would leave it the same at this point. And I appreciate that you would like us to leave the vulnerable populations in, but I don't think I can count to 4 on it. At the end of the amortization, return back the dollar amount of the increase.
Now, I'm assuming Exhibit A is part of this resolution.
The proposal is that if the ordinance were introduced tonight, that you could adopt the resolution to implement the policy. The policy would not go into effect until the ordinance went into effect. But it would be appropriate to, if you want to do something with the policy tonight and you're satisfied with most of it, to take action on it tonight, correct?
Okay.
I'm okay with the reset. I do think that 15 years, that's a 6%, 7% return. I could go to 20 on that for 5% simple.
I will take advice from the CPA on council.
So am I hearing that the amortization period will be set for 20 years, and at the end of that 20-year period, the rent increase that was approved would be eliminated? Is that the direction?
Yes, that's the direction. On page 3, number 5, calculation of rent increase for capital improvements, there was a suggestion that this not be Wall Street Journal's prime rate, but that it be some kind of savings rate. Can you repeat what your suggestion was, Mr. Wysocki?
Well, I was just questioning as to where that, I understand it's an arbitrary rate that was picked. Is it generally higher than because the rationale being that the money would be earning interest?
Correct.
So is that a higher rate than the institutions pay out around in local institutions?
Yes, I mean, that is the rate that typically a well-qualified applicant would pay for a construction loan, was basically at that a prime rate plus 1%. So that's where that number came from.
It seems to be a higher rate. I would suggest to keep it simple. Let's just divide that rate in two.
Wall Street Journal prime rate plus 1% divided by 2 is simple.
I guess it depends on where you're at. But
Okay. I'm all right with that if I have support for that. Does that work? Okay. I had 2 comments about water conservation devices. One of them was to mention in the language, taking into account any available credits that are that may or may not be present during water conservation device installation, solar device installation. Was there another comment on that?
my comment is a lot of times that those, while they may be substantial, they aren't utilized until a year or maybe 2 or 3 years down the road, depending upon the individual's tax liability. So I don't know how we confirm that. Do we just assume that they're going to use that?
I think if the landlord is bringing the petition forward, that would be included in their information as they petition. Is that, am I hearing that correctly?
Yeah, it does seem a little problematic to me, but maybe not for somebody who deals in this all the time, how you would translate those credits into calculating what the appropriate rent increase should be. I'm not saying it couldn't be done, but it does seem a little murky.
We are assuming that they're going to get those credits, and we don't know that for a fact.
But we do, and I would make the case that we want this action to happen. We want people to do this in their units.
Right.
So I would be tempted to not take the credits into account as a way of encouraging the installation. Is that a problem?
I want to incentivize that, sure.
I think that's why it's here in the
Can we
first
just
place.
have the program administrator keep this in mind when they're making their determinations on this?
Okay, so the program administrator may consider tax credits.
Yeah.
Is using the may language?
Okay, that works.
Okay, how's that? That's my list. Does it match yours? Did I miss anything?
The penalties, the first penalty, the referral to an education,
Thank you.
is that the very first, or is that reset every year? I would say the first time they get a free pass, get out of jail free card. After that, they can.
You're right, I missed a page.
Go with the language as written. Are there others? And then on section.
So would you repeat that? I'm sorry, I'm just trying to make sure I have it right. On the penalties.
First violation is a referral to an education program.
Without a cost.
Correct.
Yes. I accept that. After the education program, penalties would be per unit.
Per unit worth of violation.
Yes, sir. Not just one penalty, but penalties per
That is
violation, per
distinctly
unit
different.
violation.
That's distinctly different what's in there.
It's not clear what's in there.
Well, for example, let's say that there were 10 units and the landlord had improperly or willfully charged rents more than he or she should have. If I'm hearing the direction correctly, you would want, let's say this is the second time through, you would want a separate citation for each of those units for which the rent had been calculated and imposed higher, as opposed to, oh, you did it for 10 units, here's one citation.
That's correct.
That's what you want, correct?
That's what I'm looking for. on the assumption that it's a free pass the first time with an education program. Okay.
I'd like to hear from my colleagues on that. Okay.
Okay? We're good.
Okay.
Was there, let me see, was there anything else?
Change in rental conditions, I brought up about the pets, the limitation on pets. Does that need to be explicit, or is that's section 045,
Oh, yes,
I believe?
the pets policy.
If the council wants that pet policy in there, I need
Right.
that direction.
Yes, if there has been previous approval of pets, you can't evict someone for having a pet after the change. It's like, I don't know how to word the grandfather clause, and I'm trying not to say that phrase. So help me figure out how to say that.
Well, let me, without getting too nuanced in it, let's assume that a tenant has a pet and it's been allowed.
Yes.
And let's say the owner then changes the policy for new tenants.
Yes. They can change it for new tenants.
If that pet dies, is the tenant allowed to get a new pet, or basically it runs till the pet goes away?
I would say that tenant has been allowed to have a pet. They should remain, that allowance should remain.
Where are you on this, Chris? Okay, I'm going with them.
Okay.
So we're saying that the unit permanently has a pet allowed if a pet's allowed.
Right, until that,
Okay.
right, until the
tenant leaves.
Till the tenant leaves, not till the pet leaves. Okay. Anybody else?
I just want to come back as a dog in America.
I want to come back as a baby in Italy.
Did you, I may have missed this, but did you cover on page 12.075 the requirement that two tenants must make a request for an adjustment of rent?
I'm glad you caught that. I think I was looking at the 30 days and missed the 2 tenths. So I think we agree that we don't like this language for frivolity, and that we would eliminate this language. I would give the administrator a chance to talk to us about frivolous, but I would not include it here.
And also the only one request every 12 months, you want to delete that as well?
Yes, please.
I'm actually okay with making only one request every 12 months. The landlord can only raise the rent once every 12 months, so an adjustment request should be sufficient once every 12 months.
The reason that I would eliminate this is because if the tenant has gone to request that the rent not go up, and that's their request, and the landlord then takes a possibly retaliatory action, the tenant doesn't have a right to come forward and talk about that action.
Well,
So this only applies to adjustment of rent questions, is that?
Yeah, I was thinking.
Okay, I want to make that clear then.
Yeah, I was thinking it was with respect to essentially the same item. So, for example, if there was, a miscalculation of rent, and that was decided, and then subsequently there was some retaliation because of that, I wouldn't read this to preclude that. It was the idea that coming back with the same item over and over again was what that was intended to do.
If we can clarify that language in some way.
Sure.
Because I have concern about, for example, if a parking space is removed from a tenant, because that actually is a reduction of, that's an increase in rent. So if they've brought forward an increase in rent complaint and then they're reduced in services as a retaliation, I need this language to be clear enough that it's recurrent about the same issue. And then I have no trouble with it. Anything else?
The HUD buildings, the Section 8 buildings, did we want to address that? It's not addressed at all.
My recollection was that language had some Costa-Hawkins in it. Is that not part of Costa-Hawkins? That
I'm not sure I caught the full.
the HUD exclusion, the exclusion of HUD units of government programs, I'm trying to remember where that language originated, and I thought it might be Costa-Hawkins, so I would like to confirm.
I don't believe that's part of Costa-Hawkins. I think
Great.
that it's simply,
Okay.
it was the concept that there could be conflicting regulations between the Section 8 program and this ordinance, and rather than have that potential, exclude them.
I already know of a housing unit that was helped by our 3% moratorium for multiple tenants, and yet one tenant had HUD, and their rent went double what the other people's rent was, which made them not able to continue to live there. So I have no problem removing that section.
Section 20B, is that what, yeah, page 6 of 24.
I thought it was a requirement of Costa-Hawkins. That's why I have never questioned it. So it was my mistake in my reading.
Can we have staff research whether that will cause any conflicts or problems with federal regulations?
As we were looking at that eventuality and looking at what other communities have done with this very same subject, at present, we're only aware of the city of San Francisco, who had returned with their ordinance to include voucher holders. And so it would be my suggestion to let's monitor that as a potential impact in this first year of operation, return with some recommendations.
Can we do the opposite? Can we accept the modification and monitor it, and if we have impacts change, make the changes?
Certainly you could do that as well.
Yeah, I'd rather do that.
All right.
Thank you. Anything else?
Yeah, I don't think we've addressed the question about redevelopment of a property.
It's a tough question, and I really don't know I can give you a definitive answer in terms of whether or not Costa-Hawkins would apply to that or not. The ordinance is written certainly when there's a demolition and the property owner intends to take remove the property entirely from the rental market, there's no question that it's covered here. But when you have it being removed and then a brand new unit being constructed there.
If I may ask you a question, don't they get a certification, occupancy certificate?
There would certainly be, if there was a brand new unit being constructed, you would get a certificate of occupancy for that, and it would be post 1995, clearly.
So that would pretty much, in my mind, that's pretty clear.
Yeah.
Is it possible to put a time limit so that there's a time between when it's demolished and when, I mean, we wouldn't want to do that either.
I just think if it's a new certificate of occupancy, state law would preclude them. I mean, I'm not the attorney, but
I think I would move forward with the way it's written now and ask for.
I would urge you all to, I mean, in these cases, you may be building a fatal flaw into
Yes.
your ordinance, and because this is really open territory, this is probably why this is one of those challenging places. We can continue to monitor the situation, report back, do additional research, but I think you're going to walk into potentially
Yes.
a concern that both Michael and I have about where this would end up, because there's a huge amount of uncertainty here.
Are you comfortable if we move forward and revisit this question? Okay, we'll move forward. Is there anything else? Okay, I'm going to read the motion as amended. Ordinance of the Council of the City of Santa Rosa adding Chapter 6-90 to the Santa Rosa Municipal Code concerning as to certain residential rental units in the city. A, rent stabilization, limitations on the termination of tenancies, and the payment of relocation assistance, and repealing in their entirety ordinance numbers 4067, 4069, and as amended?
Well, this is, that last parenthetical is the item that is on your agenda next, because this is the ordinance that was introduced there's your just cause eviction ordinance that has not been adopted. If And so the question would really be is if you introduce this ordinance tonight, which it sounds like you're going to do, whether or not you feel the need to adopt the subsequent ordinance that deals with the just cause eviction, because there will be basically a 2-week overlap or a 2-week gap, as it were, if you if you didn't adopt it.
We need to adopt the just cause eviction ordinance separately in order to speed the just cause eviction ordinance implementation. Is that correct?
That is correct.
Then let's do that.
Then there would be, then you would.
It is as I read it?
You would want to repeal that ordinance when this ordinance goes into effect. So we'll leave that number vacant until we know what that ordinance number is.
Thank you.
Thank you.
So I'm going to leave it as numbers 4067, 4069, and as amended, and waive further reading of the text.
We have a motion. Do we have a second?
Second.
We have a motion and a second. So now we entertain any other final comments before we vote. Let's start down here, and if you have anything else you'd like to add.
No, thank you, Mr. Vice Mayor.
I appreciate the patience of the council, the participation of the public, the work of staff. This is a difficult and historic moment for our city, and I appreciate that we are protecting tenants who live here now.
No comments. Mr. Olivares, would you like to make any comments?
Thank you, Mr. Vice Mayor. I had expressed some concerns in the past when we discussed rent stabilization. I was expecting a little more clarity. It still lacks clarity for me. I'm still concerned about the lack of clarity, the lack of research and analysis, and really at the end, it's the fairness of this ordinance, because it's really only going to be applying to a number of members of our community who need it. It seems like we're making some arbitrary decisions in setting policy here, even with continuing to make edits. I don't purport to be an expert in this area. I don't know that any of us are, but we've made significant changes and additions to the ordinance even tonight. And again, even that without the benefit of research and analysis in justifying those numbers or decisions. For me, it's difficult to just pick a number and hope that it's going to stick for us, because it may not. This truly is not protection for all. I think it really is some arbitrary protections for some, possibly, but at the end, I think it does very little to address our need for affordable housing, and that is going to be, that will continue to be a very, very big crisis for us, and I would like us to see some movement in that area and expedite some of our efforts in getting to some meaningful solutions to affordable housing in our community.
Thank you, Mr. Osaki.
Thank you, Mr. Vice Mayor. I do want to thank staff and our consultants for their work, and my colleagues for their patience and for their diligence as well. No, this is not an easy decision to implement such an ordinance, but if you look at the staff report, the rent increases for the past year have been at 9%, last 2.5 years, 20%. 47% of Santa Rosa rental households are overpaying by federal standards, which means more than 30% of their household income is going to rent. That's objective. We've had presentations in the last 2 meetings, just last meeting, the violence prevention program. One of the scorecards markers was rent stabilization is key to reducing violence. Homeless emergency has been declared by this council. What is the #1 cause of new homelessness? The lack of affordable shelter. So the need is definitely there. I'm hopeful that supply will increase through our other efforts. This is just one step of a comprehensive plan. There are other elements moving forward. I wish it would have happened yesterday, the other elements, but I understand staff limitations. So I will be voting for this ordinance. I do feel that just because state law only allows us to protect some doesn't mean we leave them behind.
Thank you. And I also want to applaud staff because I know how complex this is, having participated in many of the conversations in this chamber and with the subcommittee and talking to many members of the community. There's no easy answers. Again, I believe that we can all agree on what the problem is. The solution is where we may disagree, and that's where I have landed on this. For me, the major or my most significant issue with rent stabilization is I think it's going to have a negative impact on creating housing. I think people are going to be looking, developers, those that might bring housing to this community will be looking at Santa Rosa and going elsewhere. And again, I recognize that housing is the key solution to homelessness, and I think this is going to have a negative impact on that. Secondly, also related to housing, we're trying to adopt a housing first approach, and part of that approach is a program called rapid rehousing. For rapid rehousing, we need to have landlords willing to rent to this population. And with just cause eviction, I think it's creating another barrier that's going to make it more challenging for us to identify landlords willing to participate with some of our rapid rehousing efforts. So with that, we have a motion, a second. I ask for your votes. And motion passes. We have 4 ayes with Oliveras and Trejo no and Mayor Sawyer abstaining. And with that, counts.
This is followed by a resolution.
Oh, please, I'm sorry.
And the resolution of the Council of the City of Santa Rosa adopting a policy concerning capital improvement plans for rental units in the City of Santa Rosa and waive further reading of the text.
Second.
Have a motion and a second. Your votes? And we have 4 ayes and 2 noes with Councilmember Oliveras and Vice Mayor Schwedo voting no.
Can we do the just cause before we break?
I've had a request from the mayor that we take our break at this point. So why don't we take council will be taking a 20-minute dinner break and re-adjourning.
I believe that the request was actually to do it after the just cause. That's the way it's listed on the agenda. But
if that's fine. I was just getting a piece of information that
I hate to have the members of the public have to wait through our dinner break for just cause if many of them are.
I agree. If the city manager is believing that's the interpretation, and since the note was handed from, that's fine. So why don't we go ahead, Mr. City Manager, next item.
Thank you.
Item 13.2, report, ordinance adoption, ordinance of the Council of the City of Santa Rosa requiring just cause for tenant evictions in the City of Santa Rosa. This item was continued from the August 2nd, 2016 regular meeting. It's just a vote. Just a second.
Are there cards on this item? I'm just asking. Okay, thank you.
So I'm sorry, Mr. City Manager. So that is
There
the
is no presentation. This is the second reading of the ordinance.
Okay. Council, any questions of staff? Then I'll move to.
I have a question of staff. Has this been brought to us in 2 versions so that if we were to amend the coverage?
Remember, this is the second reading of the ordinance.
If we want to amend the coverage, how do we?
I would defer to council on that.
It currently only covers the same properties as the rent stabilization ordinance, but it does not have the Costa-Hawkins limitations. If we wanted to have it passed now with in mind the future needs of our rental inspection program, can we do that tonight?
It would seem to me that if you are going to now have the just cause eviction apply to essentially all the rental units in the city, that's what you're asking.
Yes.
I would think you would need to reintroduce the ordinance, and that also would be, whether it's good or bad, inconsistent with what the previous ordinance did, because the previous ordinance as introduced did not have that exemption.
I understand.
Okay, but I would say if you're going to do that, we would need to reintroduce the ordinance because it's really a very substantive change.
Can we read the ordinance twice, once this way, vote on it, and once the second way and vote on it?
Not in the same meeting.
Thank you.
So no more questions? All right. So several cards here. First up, Pauline Laurent, followed by Courtney Cox. Hold on just a sec till you make it. There you go.
Thank you so much for your hard work and your commitment to our community. I spoke once before about my fear of speaking up. My property owner is in violation of the whatever this is, the last time that you voted on this, there's paragraph 16, which states that if they gave you notice of a rent increase after the date of June 23rd, my rent increase is scheduled to begin October 1st. And I spoke to my property manager and said, you know, the management should be sending us a note saying that our rent will not go up. And she said, no, 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 they are in compliance. I'm afraid to speak up and say they're not in compliance, and I have contacted a lawyer. Please have them be in compliance. I think the just cause clause would protect me so that I would feel confident to speak up for my rights. So I'm asking that the cause be passed tonight if possible, and thank you for your time you're spending. That's all.
Thank you. Courtney, followed by Marlena Martorano.
All right. Hello, my name is Courtney Cox. I'm a full-time student at the JC. I'm 21 years old and I'm a farmhand. And I just wanted to thank you for all your efforts. And you're really doing a great job, all of you guys. Go job. All right. And I just wanted to say that we are in a state of emergency with homelessness. And I think that without just cause eviction, we will be contributing to homelessness. We need to keep tenants in their homes, and we should not contribute to the already 3,000 homeless. I think that landlords, as many people have stated, they have their protections. They have all of their shady people behind them. And when it comes to the people, we don't have a lot of protections. And so thank you for protecting us and keeping us in mind. And as well, just saying, I'm 21 years old, adulting is hard, and like having to worry about getting kicked out of my apartment where I live with 2 other adults, it's terrifying. Being a full-time student, trying to make it here, it's hard. So if you want to keep students here, if you want to keep that bustling group, we're here, we're working towards this. So if you want to keep us here and keep us in our homes and studying and working hard to be productive members of the community, you're on the right track, and I hope you guys keep doing that. Right on. Thank you.
Thank you, Courtney. Marlena, followed by Dwayne DeWitt.
Hello, my name is Marlena Martorano. Thank you again for the opportunity to speak. I'm here today to plead for just cause protections for all renters. While the landlord-tenant relationship is a somewhat odd one, however, it is the only system we have. Pardon me. I often hear landlords declare in a very angry tone, "It's my property, I can do what I want." True, but when one rents their property, conditions are legally different. According to California law, a tenant has contracted for possession of the rental property, which means it's exclusive use and enjoyment. That's what renting is. It appears that more tenants have read and are familiar with California civil codes than landlords. Landlords don't need to, generally. And really, how about a little thankfulness that one has the enormous privilege of making passive income from something someone needs and is essential for life: a roof, a home, shelter, safety. Passive income meaning income received on a regular basis with little effort required to maintain it. Dedicated attorneys from Legal Aid and CRLA volunteer their time and expertise in helping tenants retain their housing. However, even before appearing before the judge, as with Ms. Sussman and her client that lost her home of 18 years, they are defeated because of no-cause evictions. That's disheartening and really just plain wrong. In a recent O.J. Simpson documentary, I was fascinated by the comments of O.J.'s former friends and their original reasons for supporting him, despite the overwhelming evidence that he probably committed the murders. Things like, I know it sounds crazy, but I wanted so badly to believe he didn't do it, and I didn't want to believe he did it. Similarly, we want to believe most landlords are good, but we have to look at the overwhelming suffering and displacement of tenants and deal with that. Prosecuting attorney Marcia Clark said, the O.J. case was a case about blood. Metaphorically and viscerally, for me anyway, and a lot of other people, our housing crisis is too. We have to stop the bleeding, as Councilmember Combs expressed. Please, please pass just cause for all tenants. Other cities are watching. We have to give them hope. Too many raisins in the sun. Thank you very much.
Thank you. Is Dwayne DeWitt still here? Not seeing him. Michael Hilber, followed by Peter Chernoff.
Okay, Michael Hilber. If this is being limited to the same stock of apartments as rent stabilization, and my comments are not particularly relevant, but I just wanted to share that one of my neighbors, a woman in her 60s, got kicked out of her small rental home, without cause, and happened to be in a dispute over marijuana farming. One of my observations is that throughout the period of 2010, when there were so many foreclosures, it seemed like most of what was out in my neighborhood got snatched up by investors for cash. They languished on the market for quite a while, and at some point they went down enough and it looked like the market was going to turn. They all started getting snatched up by investors. I'd say something like 80% of them, because I talked to whoever moved in, and they were rarely homeowners. They would be tenants of investor-owned properties. And that's disturbing because, these are like the ideal type of small 2 bedrooms and not in particularly good shape that makes them good fixer-upper starter homes for people. But, it's taken the opportunity away for first-time home buyers. And this particular lady, I got to know her, and at some point they put a second home, like a prefab place out in the back, and they rented to some young guy who decided to start growing marijuana. I don't even know if they're supposed to have 2 houses on that piece of land, but anyway, they did. And, he had couple of pit bulls to guard his marijuana plants. She said he had about a couple hundred there, and they tried to bite her as she was coming home and trying to get out of her car, so the law enforcement came out and all that. And so one of the things is like the investor is seeing more money can be collected from marijuana farmers than an ordinary person is going to pay rent. So she just got an eviction notice, no cause, no nothing, just get out.
Thank you, Peter Chernoff, followed by Thomas Ells.
Oh, good evening again. I dare, I care, and now I will share regarding predictions regarding evictions. A few thoughts thereof. One of them being that starting today, permission is granted that everybody's PG&E and water utility bill, no matter what the bill actually says, will now have to pay only $10 a month. People in True Authority have all agreed, so you people need to just pay $10 a month, so that's good news. And I say, great, a brand new slate. 40-day strike. We shut down that West Coast till DC and Wall Street is toast. And I say, why be hesitant? Let's go ahead and put Gary Wysocki in as president. So we've got, who can afford to live around here anymore? Bankers, lawyers, drug dealers, traffickers, Silicon Valley and Hewlett-Packard CIA operatives, and maybe some movie stars. And as I look out there, I say, hey, superstar, let's all be movie stars. Movie stars as you like, because there's many starring roles during the general strike. So I will tell you that what I'm going to say won't be pretty again, I warn you. There's 255,000 bar lawyers in California. The hard-working farm labor as children learn Mexicanese, while America's premier organized crime syndicate learns legalese. Surviving veterans as young men misled by bankers' propaganda status quo, till they came to see the insanity of embracing wrong directions gung-ho. Factual, quite verifiable, it be hardly an opinion that every city today be controlled by the very same bankers and lawyerly minion. This enterprise of crime be quickly running out of time, for their deceiving tools be the debate and to calculate how to pick every pocket and fund the military rocket, time to pull their plug right out of its socket. Imagine, if you can, embracing the 40-day plan, seeing this room full of lawyers and bankers. Yeah, the ones that maintain the wars and oil tankers. Imagine, here they are sitting in front of and begging the council to demand that the citizenry go back to work and start paying their rent. The 40-day prophetic strike be heaven sent. Imagine the bankers and lawyers all sitting in your seats begging them to ask you to go back to work. Stop funding your own demise. It's not a matter of lawyerly compromise. I say go ahead and open your eyes. Take off your disguise. You're the superhero. You are the superstar. You are the movie star. And there's many roles to be played during the general strike. I say it, you hear it, so be it. We have been taught to disregard the lessons of Gandhi and King. These are the strikes and actions that made our hearts sing.
Thank you, Peter. Thomas Ells.
Hi, thank you again for addressing the just cause eviction, and separately, it's important to cover those initially here in the gap period. But what I want to speak to is just cause eviction for all in Santa Rosa, and I spoke to that last time, and I said, well, Costa-Hawkins didn't cover single-family residences, and really thinking about it, actually those residences and all residences in Santa Rosa deserve this coverage of just cause eviction. All tenant residences deserve just cause evictions because there can be the force of those evictions which cause rapid increases in rents across the board. And then that's compared then to what is a reasonable return of someone else. So now we have the South Bay and investment-oriented, tech investment-oriented people seeking 50%, 100% return of investment per year. 50% is not uncommon. This is what they're looking for. Man just mentioned the purchase of a building and the return that he received, the increase was $1 million. Do you think he put more than $1 million down on that building? Or that any more than $1 million was his total investment? I mean, because he got the rent for the years that he had it, right? So he had no other further investment in that other than his down payment, and he received $1 million. So that's 100% a return in 1 year. That's how that's measured. And that's what they want, 50 and 100% return per year. It doesn't sound like you or any of us would really think that that's like reasonable. You wouldn't expect that. You wouldn't look for that, and you don't think that anyone would even think that that's reasonable, but there are people out there, that's what they want. That's the only thing they want. It's 100%, 50%, and 100% return per year. And that's what they can do if they can force evictions at the higher levels of interest, of rents, and they can make it appear that these are the kinds of returns that are necessary. And we know that's not true. And we don't want that to be true, because the kind of dynamic change that occurs when you're looking at that, we saw that. We had 15% treasury bonds. We had 18, 19, 20, 25% construction loans. It's very disruptive. And that's far less than the 50 to 100% returns that people are seeking. They want to extend that up here to the North Bay, and we can't sustain that. That kind of change can't be sustained. Thank you.
Thank you, Thomas. Those are all the cards I have. Mr. Wasaki, you have this item?
I do. I do have two questions, though, on this item, and that is the exemptions. Under Section 6B, habitual late payment of rent, is that going to have the same definition as the previous item, 13.1?
In this ordinance, it doesn't totally reflect what is in the ordinance that the council introduced earlier tonight. Certainly, when we did the more permanent legislation, we expounded on this definition to make it more clear in terms of what habitually late meant. But my suggestion would be that you leave this as it is, because this ordinance is going to be repealed, presumably, once the permanent legislation comes into effect.
I understand that. So then the same answer would go for Section 6J, owner or relative occupancy resident manager, as it relates to triplexes. As we also discussed, it would be the same. Okay, and I'm fine with that. Okay. So with those answers, I'd like to introduce an ordinance of the Council of the City of Santa Rosa requiring just cause for tenant evictions in the City of Santa Rosa and waive further reading of the text.
Second.
We have a motion and a second. Any comments by council?
I have a question.
Ms. Combs?
Can you clarify for me, when we bring this ordinance back, something happens to this ordinance? Can you clarify that connection?
Sure. The ordinance, our intent will be to bring back a second reading of the ordinance you introduced tonight on August 30th.
Yes.
It will go into effect 30 days thereafter, October, either doing the math, October 1st in round numbers. This ordinance tonight that you are adopting, assuming there's 4 votes, will go into effect 30 days after that, which would be mid-September of 2016. The intent of the ordinance you introduced tonight is basically to replace, however, these provisions. So the ordinance you introduced tonight will repeal the ordinance that you are adopting tonight once the new ordinance goes into effect. So in other words, this will last for approximately 2.5 weeks.
So I understand this is we're bridging to protection. I understand that. What I'm trying to understand is the just cause language in the other document. This document on page 4 has section GH. It has H. And if we eliminated H, we would provide protections for all renters.
So as I had anticipated in structuring this, is this part of the reason I had asked for this thing consideration is because we weren't sure what was going to happen with the earlier item or the direction with the earlier item. My concern with this item and moving this item into effect is that it has some contradictions to the ultimate item. And so my question for council has been from the beginning, do you want to, because these were moving targets by the time we got to this item, we'd be adopting 2 weeks of this, ending up with the ultimate ordinance. And my concern is, and has been from the beginning, that this could potentially create more confusion because the ultimate ordinance is going to be different than this ordinance. And that was because this was being brought forward back on July 19th to bridge the gap till we got till the permanent ordinance. As we get closer to those periods of time, this is the conflict within this. We will have to manage exactly the questions that are coming out right now. And so I put it out to council just like I did before. We are not trying to not have the just cause eviction. By adopting this just cause eviction, it is 2 weeks of additional work that staff we will have some confusion. And there will be confusion with because it's ultimately a different just cause of ordinance. The only reason this was brought back, as we had those conversations a couple weeks ago, we delayed this, is we weren't certain what the earlier action was going to be tonight. So I will just, there are differences because these were working in progress. So yes, if you adopt this evening, if you do the second reading, and again, Michael wasn't here for some of this conversation, if you adopt this evening, we will have, as staff, manage 2 weeks of this, which is not exactly the same as the just cause eviction ordinance that you've just moved forward later. This was here as a safety net as it was originally turned on the 19th.
Right.
It had failed motion. It was not that it had been defeated motion. It had been a failed motion, so it is hanging out there. So you have within your ability to move this item, and we will manage the 2 weeks of incongruity, or you can defeat the item formally, and then we will move into the other item.
Mr. Corsi?
Could you describe briefly the differences?
I think
You know, because I have not been dealing with the drafting of the ordinance on for second reading, I would have to spend a little time to try to tell you where the differences are. Apparently, there's been a couple of comments made, for example, on the habitual late payment of rent. We've clarified that better in the permanent legislation. There must be some issue with respect to the correction of the violations in the government order that perhaps is contradictory to what the permanent legislation says. There undoubtedly are, I think there's probably some differences with respect to the owner or relative occupancy. We've cleaned that up, added some language. You know, the differences may not be major, but there are some differences between the two.
And again, we can survive that. I do think there will be questions around that, but the reason we asked for deferrals, we didn't know what the earlier action this evening was going to be. So there are built-in
I get
contradictions.
that. I was wondering if there was something more major differences between the two than we had already heard. It doesn't sound like there are. And, you know, I think that the reason that we brought this one forward in the first place was to close a gap. And we can't close it completely, but I think we should close it as much as we can, so I would support it.
I agree, I'll support it.
Any other questions or comments? So we have a motion and a second. Your votes, please. And motion passes. 4 ayes, 2 noes. Councilmember Oliveras and Vice Mayor Schwedhelm voting no. So with that, council will be taking a 20-minute dinner break.
Okay, welcome back, and we are going to start with our public comment, or it is after 5, isn't it? Yes, it's after 5 o'clock. We can have our first public comment period of the evening, starting with Brian Wims. Is Brian still here? Richard Canini. Is Mr. Canini still here? This is going to go rather rapidly. Mr. Hilber.
Can I have the projector?
Yes. Ms. Gomez, could you get the overhead going for us? Thank you.
Good evening, but I'm not too happy. I'm going to continue on where I was last time. It's not showing anything.
There you go.
Last time I was here, I was complaining about, I was saying I believe that the fire department is incompetently and unlawfully trying to fine property owners for violating city weed ordinance even when their homes are outside the city limits. And I said I don't think there's legal authority for that. Well, I got a letter from the fire department on that issue here, and I don't think it's very good. But anyway, on that previous occasion, I spoke to your fire chief, and I asked him, what right do you have to fine us for violating city weed ordinance, even though we're outside the city limits? And he said it's because he works for the city of Santa Rosa. I found that to be a ridiculous answer. And then I went on to ask him, you know, there's a 3-acre parcel owned by somebody else behind me that's never had the grass mowed. How can that be? And he said, well, we only cite what we can see from the street. So I'm saying that's not lawful because it's unequal application of the ordinance. If it's going to be applied, it has to be applied to everybody, not some sort of willy-nilly unfair fashion. Now, this issue goes back, you know, many years, maybe 15, when Brian Farrell was an attorney, and I said to him, what's your legal authority for, you know, fire department fining people outside the city limits for violating the city weed ordinance? Does it even apply? And he refused to answer, and he called me back later. You know, he said he gave me the phone number of some Toby Ray with the fire department. And, you know, so Brian Farrell really didn't answer my question. And so it's just so Toby Ray could say that the city ordinance applies outside just because, like, I guess maybe he feels like it should. You know, so I'm not happy with any of these answers. Now, this letter here, in my opinion, it seems to be kind of a half-assed way of admitting that they did something wrong, and they're saying that, you know, they sent out the wrong notice, but otherwise, you know, in bold type is threatening fines and stuff. And I still don't even know what ordinance applies. And at the top of this, you see it says parcel over 5 acres. So, you know, at no time did I ever say I had a parcel over 5 acres. So it's not really relevant.
Thank you, Mr. Hilber. Dwayne DeWitt. Mr. DeWitt has left the chamber as well. At this point, I'm going to reorder the agenda and move to our second public hearing of the evening. Mr. McGlynn, 14.2, please. Sorry, I didn't let you know that I was going to do that, but we have a fire official who's had 6 hours of sleep in the last 2 days because he's been over in Lake County assisting them with their firefight. So we're going to take this public hearing.
Item 14.2, public hearing, Santa Rosa Fire Department Annual Weed Abatement Program Report. Paul Lowenthal, Assistant Fire Marshal, presenting.
Good evening, Mayor, members.
Good evening, Mayor, members of the council. This is the annual public hearing for the portion of the weed abatement process where this is the unpaid fees that were assessed for properties that were abated and or inspected that were not in compliance, and opportunity for the public to have any comments before requesting authorization to move them forward to liens through the county assessor's office.
Thank you. Council, any questions? At this point, I'll open the public hearing. I have no cards on this item, but you needn't have filled out a card. This is a public hearing. Mr. Hilber? Yes, it's here now. Thank you. And the overhead again. Thank you, Ms. Gomez.
Okay, so you're talking about applying liens on the property tax roll for properties here. That's what the title of that sheet says. Unpaid to be applied to the tax roll. I'm claiming you're not acting appropriately here, being asked to do this, and you should decline to approve it. Under what legal authority, do you have legal authority to apply property tax liens outside the city limits of Santa Rosa? Do you? I think you do not. And, a tangential question to that is, how many properties on this list are outside the city limits? Maybe you're not sure, but, being as how I live out there, I see what looks to me to be several that are outside the city limits. So I would say you should decline to approve this as it is. If you don't, I'll lodge some sort of complaint. We've seen that there's $70,000 was charged as fines, and something like half of it was paid and half of it is still unpaid. And I'm saying there's also an underlying issue of perhaps some of those were inappropriately levied in the first place, so even some of the paid fines were inappropriate. That letter from Mr. Lowenthal that I received actually said they withdrew my fine, which was, I think it was $275. But anyway, that same courtesy, if you would like it to be called, should be extended to other people in my same circumstances, and I have every reason to suspect there are quite a few that were, similarly. So the same reason that this letter was sent to me, which, among other things, it does say that my fine was withdrawn, should likewise apply to others, because I suspect they're all, my neighbors. And I have no reason to think that they have any other sort of notice than I had, and apparently he saw fit to withdraw mine. Even though it seems like he didn't even read my letter based on what he wrote to me, he found some substance in my objection to withdrawing my fine. So I'm saying you should pass on approving this.
Thank you, Mr. Hilbert. Your complaint and your concerns are duly noted. Those are the only cards that I have on this item. Would anyone else care to address the council on this item? Seeing no one rise, I'll close the public hearing, bring it back to the council. And who has this? Do you have? Okay, Mr. Corsi.
Introduce a resolution to the Council of the City of Santa Rosa confirming the itemized report of the Santa Rosa Fire Department of the cost of removing weeds and/or rubbish from, upon, or in front of certain lots or parcels of land within the City of Santa Rosa. Waive further reading of the text.
Second.
Thank you. I have a motion and a second. On your votes, council. And I have 6 ayes with Councilmember Carlstrom having left the council chamber. Thank you. Moving back. Mr. McGlynn, 13.3.
Item 13.3, report reimagining city bus route 4A/4B and Route 11, final alignments. Anita Winkler, Deputy Director Transit, presenting.
Welcome.
Thank you. Good evening, Mayor and council members. I'm here this evening to report back to you about the remnant pieces for reimagining city bus that you asked us to review further and bring back following your adoption of the plan last June 7th. There's three pieces that we want to talk about tonight. First one is the western terminus of Route 11. Second is the eastern terminus of Route 11. And then the Route 4A, 4B alignment in the Memorial Hospital area. In your packet, there should be a colored, multicolored map towards the back of your packet if you want to look at the exact locations. Okay, come on, guy. It's supposed to advance. Why is it not doing it? There, well, thank you. And it doesn't like me. There we go. So I'm going to go briefly through those 3 items as a reminder. It's been a long time since you've last seen it, and then I'll explain to you what we as staff have done looking at the different options and our recommendations. So Route 11 is the new route. We call it the, I think, the northern circulator. The route runs from Fulton Road up to, and I'm going to mess up to Fountain Grove. It's large, it's a long route. It's, as a reminder, it's a lifeline service for people who otherwise don't have a way to get around town. And there were questions about how we were turning around the bus at both ends. We held 2 neighborhood meetings. The first one was sparsely attended, and the people who attended felt they would get more people there if we did a second one. And we did that. We mailed notifications to the whole neighborhood about both meetings. We had, and about the city council meeting, Rachel Lead had a massive email file that she's used. We posted on Nextdoor. We were able to get some of the announcements in their neighborhood newsletter, and then, of course, on our project website. For the piece on the eastern side, we provided notice to the condominiums that are behind the Fountain Grove Village. The owner of the property where Sweet Tea is of the village itself contacted his tenants, but we figured we needed to let those condo owners know what we were proposing. So on the left side, you have these in your packet. The left side is the proposal that we brought to you before that ran through the Sleepy Hollow neighborhood, and they asked us to look at some other options. In the end, the one we've brought back to you is to use the Fountain Grove Village parking lot to turn around. That's where Sweet Tea is. The property owner is very willing to let us do it. He was very gracious, and his comment was that's what he can do to help City Bus. A couple of advantages to this, besides getting out of the neighborhood, is that bus stop will be a quarter mile from Quayside, and that was one of the issues we were trying to get some service up there, and a quarter mile from the Verena housing program. I don't have the full name of it. So the benefits are the bus stays on the main streets, which we've, as you know, it's been a driving force in our entire program. more coverage. In this case, we're able to keep on the main streets. Oh, didn't go, thank you. Stay on the main streets and yet provide some coverage here that we otherwise couldn't do. Walking distance to those two locations. It maintains a planned route frequency that we wanted this. Remember, this is like a 75-minute route, and we didn't want to make it any longer. And a major benefit is it maintains the existing paratransit service area. As you may recall, our original route terminated short of our current ADA paratransit service because we had a route that went up there. With this one, then we're back expanded. There's a small sliver, smaller than the new moon practically, in one area where nobody lives. And then there still remains one in the southeast that we aren't addressing right now, but we don't have anybody registered in a paratransit service in either of those locations. So if you approve this tonight, we will work out the agreement with the property owner at Fountain Grove Village and move forward. We'll bring that back to you for approval. On the western end, it was a little more difficult. This is the one that looped through the Apple Tree neighborhood. It was designed because we had that big, as you see on the right side, we had that major space between Piner and West 3rd Street with no service. So this Route 11 comes across on Guerneville, and it's Lifeline service. It's 6 trips a day. It's basically, mid-morning to mid-afternoon, but it does provide some service for some groups there who are transit dependent and need a little bit more than walking the distances they would have had to walk to catch the other buses. The map on the left is the existing service. We just wanted you to see what that route looks like right now with that large loop. The goal of this proposal is, following the rest of the effort that we've done, is to provide two-way service on Guerneville Road, eliminate lengthy waits and transfers. This is operated by a 29-foot bus, not the big 30-foot buses that you see around town. You may have seen the 29-foot bus on the existing Route 8 that is mostly in the southeast corridor and on down Santa Rosa Avenue. The bus stops on Fulton and Guerneville only. It does not stop in the Apple Tree neighborhood on any of their streets. This is a draft schedule. We haven't done the final schedule work, but this is what we think it will look like, with the buses coming every 75 minutes, every hour and 15 minutes, and it's 3 trips each direction, or 3 trips in the morning, 3 trips in the afternoon. So, as you may recall, there were a number of people that came to the public hearing who were quite concerned about going through their neighborhood. And at that time, they made some suggestions, and I think you may have had some suggestions, and then other people did. So we investigated initially 6 options that are written up in your staff report. At our meeting with the neighborhood, our second meeting 2 weeks ago, they had a couple more options, so we've investigated those. They're just not in your staff report. So I'm going to walk you through those. One was to convert, and I don't have maps of all of these, I'm sorry, but one was to take the loop and convert it to a two-way loop, which is feasible, but it doesn't meet what we're trying to do of bidirectional service on the streets and reducing travel time. It's just every time we have a loop, it's just going to be a long trip. So we didn't particularly like that because it didn't meet what the goals we were for a group of people who are transit dependent. We looked at the travel lane in front of the Rayleigh station, or the Rayleigh store. We thought that was pretty dangerous. You just get a lot of people walking through that parking lot and other traffic. So we felt that one was not safe. We looked at the delivery lane behind Rayleigh's. We thought that looked really, we had a lot of hope for that. But if those delivery trucks back up, we'd be blocked. And Rayleigh's was less than enthusiastic, and I understand that. So they suggested we look at the small back parking lot that is, the Apple Tree Extension, I think it's called. Rayleigh's was willing to work with us on that, but with the current configuration, there were chances where if a car, I don't do this well, do I? If a car was trying to get out the driveway, we probably couldn't get in, or the way it's driven, if we got in one spot and a car came through, or a large truck parked in a small parking space, we'd be stuck, we'd be blocked.
Excuse me, is the parking lot you're talking about in the upper left-hand corner of this photo?
Yeah, that's already, that was, okay. Yes, if you go to the later.
Thank you.
Yeah, it's, I think it was on before. There we go. It's this parking lot right there. There's a lot of things that are ideal about it. It was good in and out, but it's, we would have to reconfigure a fair amount, and we didn't want to incur the capital costs for a route that is truly a pilot for us to see if it works. And we'd probably have to do a parking study according to the planning department. So again, we didn't want to incur that cost. We looked at a route extension going into the youth community parking lot. And again, the way the parking lot is laid out, if there's any activity in there, we wouldn't be able to get through. Longer term, there's some possibility there if this route succeeds. And with the widening of Fulton Road, we may be able to do something. We've also got a bus stop coming in there. We may be able to do something and use that longer term. It does add some running time to what's already a pretty tight route. Then this one actually shocked me, that the source it came from, but to look at a U-turn at the protected left turn at Fulton Road and Apple Tree Drive signal, it works. We actually can do it. There's lots of things that work well. It's unorthodox, it's outside the box, and I like doing that, but this was just pushed the limit for some of us, that it just didn't feel safe or the right way to do stuff, and making a turn or U-turn with a big bus in the middle of a major street. Then the other two options that aren't on your report was one, the Aurora Hospital, which is west of Fulton, south of Guerneville Road, and is that registering with everybody? It used to be, I think years ago, it was a medical care facility, not a hospital. It's across from the emergency vet clinic, if that helps, on Fulton Road. And the neighborhood suggested that we look at that, using the parking lot that you access from Fulton, go behind the building, and there's what looks like a private road that would exit out onto Guerneville, a right turn on Guerneville. We went out the road, and the parking lot's okay. It's just any parking lot makes us a little nervous. That piece in the back looks like it's a driveway built for employees. It's about 18 feet wide, and we'd be taking our 11 feet out of the middle, basically. So nobody else could get in if we're going out. And to drive it, the edge to make a little space, it's pretty ragged asphalt, and we don't think that very edge, let alone the whole thing, would support the bus over time. So we'd have to probably go in and repave the whole thing and rebuild it. They also asked us to look at the mobile home that's on the east side of Fulton, north of College on 7 Gables Street, and I don't have the name of that complex. I'm sorry? The country? Okay. That one adds a lot of running time. That's a long ways down there. It duplicates the service that we're going to be providing, two-way service on Fulton Road via Route 6, and it would require an unprotected left turn across Fulton to get into 7 Gables Street. And we did not talk to the property owner. We didn't find this one had enough reason for us to go ahead and explore whether the property owners would let us in there. So with that, we're recommending our original proposal to turn around Apple Tree and via Apple Tree and Peterson Lane.
Ms. Winkler, just the question from Ms. Combs.
Yeah. Youth Community Park option, I know that would have required substantial capital improvements at the park as well. Is the high school close across the street from that park?
Yes.
Did we look at the high school parking lot?
I think we were asked that, somebody asked us somewhere along the line, we can't go in there with a city bus, we'd have to have school bus licenses to be able to move in there. You can't bring a bus onto the school property except for a big yellow school bus.
So we can't talk to the school board about that? It's a state level?
Yeah, state law.
So that bus would have to be
I know you'd have to have licensed school bus drivers. Whether we could find a way to put the right signage on a blue bus, I don't know. I used to be up to speed on school bus rules, but I'm not anymore.
Thank you.
Prior life.
Mr. Vice Mayor.
Thank you. Could you go to the page 9, the slide in front of the Rayleighs? So my understanding would be that if it was turned into that relatively major entrance in the parking lot, then they'd hang a right there, correct?
Which major entrance? I'm
Well,
sorry, down here?
Well,
Coming in down here, or
right,
coming in?
so
up?
option C, how would the bus enter into the lane in front of Rayleigh's?
Steve Rosa, our operations superintendent, is back here, so,
I mean, I'm familiar, I'm guessing you go in the main entrance.
yeah. So, and you just come up through this way.
And then you make a right-hand turn.
Yes.
So my question is, what's the difference between this and the Sweet Teas lot that's at the other end of Route 11?
This is a whole lot bigger lot with a whole lot more activity.
Okay, I guess I would question that. I would see it if you started from the south end of the lot, went all the way across, but with three-quarters of the way through, there's probably only, I know there's a number of businesses there. In getting into the lot, there's not cross-traffic. I mean, I'm very familiar with that parking lot, and just hanging that right there, and then once you make another right, now you're a signal light. Can you share a little bit more about potential for conflicts with pedestrian and motorists? Because I'm just seeing a lot of similarities to the Sweet Tea lot that we're recommending on that.
I'm going to ask Steve, he's driven both of them in the bus.
Sure.
Sure.
You want to turn that on?
Right, for what it's worth, I didn't actually take a bus into this lot because of what I was able to observe just driving through. It's not a very wide driveway, and what we would do is we would come in from the south driveway and go along the frontage of the entire strip mall up to Apple Tree, where we could turn right and then access
So I'm sorry, so
Fulton Road.
you would enter off of Guerneville versus turning left off of Fulton in the one-way turn lane into that parking lot?
That's correct, yeah.
Why wouldn't you eliminate three-quarters of the lot? There's a single left-hand turn lane that enters into that, go further north, right there.
Right.
Why
We
wouldn't
still
you?
have the same conflicts. It's the sheer volume of traffic in this particular strip mall. I mean, we have a Rayleigh store, several restaurants. We're not dealing with traffic volumes at the Sweet Tea turnaround like we are at the Rayleigh's turnaround. And this is a much busier lot. And quite frankly, I just don't see how this is a safer option than the one we're proposing, just because of that. It's the volume, really.
Is that a protected, unprotected left turn across Fulton?
I don't know if that's a protected or unprotected left.
Okay, well, I may have choose to disagree, but I appreciate your comments.
Sure. Mr. Westhoff?
I'd like to follow up on that. If you were to make three rights as opposed to one left, coming in from the south and do an immediate right. I see I'm pretty sure that goes all the way through. I haven't been out there in a while, but I do recall. And you'd come out on Fulton, right where the N and the R is in Fulton Road. You're not.
Steve, oh, you can see it.
You're missing most of the you're missing most of the lot.
So you're suggesting coming out down here? How are you
Correct.
going to come in?
Correct.
Where did you want us to enter? Where were you thinking of entering?
Off of Guerneville Road.
Right.
Here.
No, go. There you go. You're close. Keep going. There, bingo.
And come in here and
Turn
back
right.
out? Come back out this way?
Turn right.
We would not have the ability to access the left turn lane from there. It's too close to the intersection. We'd have to go across 3 lanes to get to the turn pocket. It's literally the length of the gas station to get over and lined up to make the left onto Guerneville Road and head east.
But this is a small bus.
It's 30 feet, yes.
My next question, which I'm a little dubious about that. I appreciate you being out there. How many 29-foot buses do we have in the fleet?
4.
So we have plenty in reserve should we have mechanical issues so that there'll always be a small bus on this route?
Yes.
And why don't we want to do the U-turn on number G? It's feasible.
It is feasible. It's a little out of the box and may look a little funny to some folks if we're doing that
People say I look funny now, so you know.
I share your faith. Councilmember Wysocki, if I could jump in, and since our traffic engineer is out here, I'll do my best to explain. This is a feasible option to make a U-turn at that location. There are some considerations we have to make for the outbound vehicles that are trying to turn right out of the shopping center. And so we would have to make some minor modifications to the location. Does it make it infeasible? No. Is it unusual to have a bus make a U-turn in the middle of a street? It's very unusual. Does it work? Yes. In fact, Steve personally took the vehicle out and made that turn several times, was able to do it within the confines of the intersection. It does work. It's just a very strange, it's just a strange movement for a bus to make.
Well, what's not strange for me is to listen to the neighbors.
Ms. Combs.
This is obviously a turn that has a lot of interest. Can you show me how you are going to get into and out of the upper parking lot, the small back parking lot described in E, if it were possible? How do you, so you would make a left turn across traffic on Fulton?
Yeah, that's a control.
That's correct.
And then go along that little bit and come in? And is the problem that when you turn in there, it's not wide enough?
As long as the lot is empty, the maneuver is easy.
Ah.
If there's something in the lot, it becomes not so easy.
So this isn't a good place to U-turn?
I would have to say honestly, sometimes it is and sometimes it isn't. It just depends on what is in there. It's kind of a delivery area, so you really can't predict what's going to be in there.
We often have T-turns and other turn locations specified for fire engines. Is there a fire engine turn space in that area or in any area around here? I mean, we typically are concerned about fire department access, so I'm wondering if that's, do we know that?
I would say the fire department, if they're responding to this location, they will come directly into the property site and go in front of the buildings.
Yeah, and they'll move your car.
And most people will get out of the way when the fire engine shows up.
Yeah, the U-turn that is an unusual maneuver, how long does the bus stay exposed to traffic in both directions when it makes a turn like that? Do we have, can the bus control the signal light? Is the concern about making that turn that the bus is more vulnerable because of how long it's in that intersection? Can you help me understand what's the problem with that, other than that it's really strange?
Part of it is the public perception of this big blue bus flipping a U-turn, and we try and tell drivers not to do that. So it's an exception. Can they do it? Yes, they can do it. The exposure, I don't know. We didn't drive it to try and test that. You really just. It's a controlled intersection, and no, we can't control the signals. We have no way to preempt or control the signals. So are they out there and they didn't complete the turn in time? Yeah.
Mr. Corsi.
Is it safe?
I'll jump in and say that's an unknown because we don't do U-turns. So there's no data to support whether or not that will be a safe turn in the long time. It's something that exists. We tried it as an unusual option. It is something that this specific bus can do. It's something that we can train the drivers to do. It's something that we would have to take additional precautions at that intersection to ensure that it can be done safe in the long term. But we don't have any data to say if it's safe or not. It's going to boil down to our professional drivers and how they react to the vehicles at that intersection.
Do you have the capability of extending the green arrow there?
Yes, we can manipulate the signal to try to help Buses do have a preempt that can allow us to get a little bit of additional green time at a specific location. I don't think it's the time of green that's the issue. I think it's the other maneuvers at the intersection that cause the concern. There are vehicles exiting out of the shopping center at Apple Tree, and there are vehicles coming southbound trying to get into Apple Tree. If those vehicles don't pay attention to the bus that they're not expecting to make a U-turn and enter into the intersection to make any of those movements, that's what creates the concern. So we would have to potentially restrict some of those movements at that intersection, which could create other problems. So that's what we're saying is it feasible? Absolutely. Are there other problems with it? Things that we would have to evaluate a little more closely.
I'm just trying to determine whether the primary issue here is safety, or if it's just that this is not the way it's usually done. And I think we're already trying to think out of the box on this issue. So as far as being not the way it's usually done, I wouldn't be so concerned. But if there's a safety issue, I'd like to hear about that.
I've never seen anything in any of the literature that evaluated the safety of a bus making a U-turn. There's nothing out there because it just isn't something that's done very, very commonly. Doesn't mean it isn't going to be safe, doesn't mean we can't do it. Well, we can do it. Steve took it out there and did it. But we don't have any information about the safety issue.
One more piece to add, if I could, please. We do have professional drivers. That's what we hire them to do. That's what we pay them to do. If we provide a location, give them specific directions and instructions, we expect that they will be safe when they're behind the wheel, regardless of the situation and situation that we put them in, if we feel if it's a feasible movement. I'm going to jump in here. I think that if I was hearing safety concerns, and I don't, when it comes to operating a bus, I don't know anything about operating a bus. What I do know is that I didn't know that U-turns were unusual. I don't think I've ever seen a bus do something that I thought, oh, I've never seen a bus do that before. And I don't think the U-turns is one of those things that I think it's inside baseball. And I'm sure that if I was a transit operator and we were suggesting doing something that was just not done very often, I would have the same concerns that you have right now. But when I read the reasons to not do it, I don't see a safety concern. It is a possibility. I might suggest that the last bullet on this page that we flip the conversation and suggest that we try operating for 3 months with the U-turn. And if we find that there are concerns about that we then reconsider the Apple Tree Drive and Peterson Lane alternative. It gives us an opportunity, and I love the fact that you are thinking outside the box. And I think that at all times when we're dealing with issues like this that affect neighborhoods and neighbors, and also trying to deal with a complicated bus route and system, that we thinking outside the box is probably not too common, and you've done a really great job of coming up with some alternatives. I just think we should maybe give it a shot. I think that's where I would go and see if this U-turn is indeed problematic, and if so, come back before us and say, this is not working very well, and then see where it goes. That's where I would go at this point. Ms. Combs?
Do we require any capital improvements at Fulton Road in order to do a trial run for 3 months? Does the road need to be widened before the trial run occurs?
I believe at this point in talking to the traffic engineer that the only thing we'll have to make a consideration is whether we prohibit a U-turn on a red movement that would allow the bus to have an unobstructed turn, at least in the short term. So we'll be discussing that more with the traffic engineer.
Prohibit a right turn? You said prohibit a U-turn on a red.
I'm sorry, prohibit the free right turn coming out of Apple Tree, out of the shopping center, so that the bus can make an unobstructed U-turn.
Thank you.
Mr. Oliveris.
Thank you, Mayor. Based on current conditions with all the options that you have, I know we cannot guarantee absolute safety, nobody can do that, but based on your assessment, which of these is the safest route given current conditions?
think we'd probably fall back to our original recommendation. I know the neighborhood has some concerns about safety. We don't believe those are issues. Well, we recognize they're issues. We don't think that there'll be a problem there. I know that Steve's driven it, and he's comfortable that we can do the U-turn. We just don't know.
I'm trying to find a way of minimizing risk to folks, and I know that we have professional drivers, but we also have to watch for other drivers as well and other obstacles that may get in our way. So I tend to like the idea of a trial run. My preference would be to do a trial run on both, because I want to see which one of those is a safer alternative. I think at the end, as best we can get to a safe route for pedestrians, cars, everybody concerned, I think we need to test them both to see which one is going to be the safest, and then go with that. But I'm kind of leery about making a big expenditure, though, on a trial run. So I think as best we can, make it happen. But that would be my recommendation, is try and both, see which one is the safest.
Not a bad idea, if it's feasible to do.
If I may, I didn't want to leave anybody with the impression there's a big capital investment at all for doing the U-turn. So there's something to do with the signals, but we don't have to do anything structurally to anything around there.
I think it's also good to get feedback from the drivers. I mean, it's driving a bus, and they don't normally do that, so they have to be comfortable making a U-turn.
They're probably going to think we lost our minds.
Well, right.
It's going to be a challenge.
It's going to be a big change because they have not been trained to do that. So that's a concern of mine as well. As professional as they are, now they have to learn how to make that maneuver safely. So I think as safely as we can, I would like to see an evaluation of both to see how we can choose the safest alternative.
Thank you. Mr. Whitestock?
Should we follow my colleague's suggestion and do a trial run on both? How confusing would that be to the public?
I don't think it's going to confuse them at all, because nobody's getting on the bus in that turnaround. And nobody will be boarding the bus in the Apple Tree neighborhood. And no matter where we turn, we get back where we need to be to get the next bus stop. So I don't think, and we'd have to figure out how to do it, but.
So there's no bus stops between the corner of Guerneville and Fulton and Peterson? Based on what you just said?
I'm sorry, based on the recommendation we brought forward, there would be no eastbound stops between Fulton and Peterson. If we were to do the U-turn, there's an opportunity to place a stop. There's some old abandoned Sonoma County Transit stops along that stretch.
Right.
If we were going to do a trial period, I think I would probably not be inclined to place a stop in that eastbound direction before Peterson, just in case we start doing, if we were to start doing the U-turn and we find out this is a disaster, we can't do this anymore, then we would have to eliminate a stop that people might be used to using. So I don't want to put something out there and then have to take it away.
So do we have a stop then at Guerneville and Fulton? It's probably on the right turn.
Yes.
Okay.
Okay, so I think I think we've probably touched on everything we can with this particular piece. Let's go ahead and move on.
That's right, there's more than just this.
Yes, there is. But this was one of the sticky wickets.
Okay, so we're going to move on. We're going to change routes. We're going to change, this is the route 4A, 4B. We evaluated, at your request, additional options for alignment in the Memorial Hospital area. We actually went out and walked both Montgomery Drive and Sonoma Avenue within a couple blocks of the hospital, and have a very rough map of all the medical facilities there. Rachel E. did it, and she went inside each of them to check and make sure they were medical facilities. And it's roughly the same amount of medical facilities fronting each street, not counting, of course, the hospital. That's kind of the big piece there. We didn't have access to the people who might be affected by making these changes, so we just posted the bus stops. That was the only way we knew to get hold of those riders. It's not a neighborhood kind of function there. And they were bilingual rider alerts at the bus stops. We used our email system that we had built, email stakeholders, anybody we would think of, put it on the project website. We had a total over the entire time that we've been talking about this, we had 11 responses, 9 you had in front of you at the public hearing. They were in the summary of all the comments for the public hearing. And then 2 people came. We had a little outreach just before the last time we were in front of you, and they came up to City Hall, and we had 2 people comment on it there. They weren't enthused, I would say. We did talk to the hospital, to the staff at the hospital, and their comment was it's highly unlikely that their patients ride the bus to the hospital. They think it's more their employees. They said, frankly, they didn't see an issue for the employees walking an extra block. And they said, so at this point, they aren't concerned, but if there turned to be an uproar, then they'd want to talk to us some more about it. But there's not anything that indicates an uproar at this point. We had nobody respond to the postings that we put out. I got a bunch of extra stuff here. So talking through the alignments, the original, as you may recall, was to combine the routes that run out there now into bi-directional service on Sonoma, and we would not be serving Memorial Hospital directly. This helps. We were asked when we started this to incorporate county transit into our system as if it were part of the system, and this does that. The county does run on Sonoma Avenue. I think they run every couple of hours, not as frequently as we do, but they run from the transit mall straight down there. So it's
Montgomery Drive.
Excuse me, Montgomery Drive. Yeah, not on Sonoma. So this gets us back to that theory. This is one of our major routes, one of the major pieces of our service where we wanted to focus the service to where it's the most ridership. There are right now roughly twice as many trips on Sonoma Avenue as there are on Montgomery under our current system. And that actually led to about twice as much ridership on Sonoma Avenue as on Montgomery. And it's very weird at the stops that people weren't using the stops we thought they would to get to the hospital. So we had the original proposal that I just went over. Then we were looking at putting the service entirely on Montgomery Drive as an option. Does it work? Yes. We think it would add additional running time because of the configuration of Farmers Lane at Montgomery Village. The buses just have to make more left turns through that area. And the ridership on Montgomery Drive right now is roughly half of the ridership on Sonoma. And we simply don't know if that's because it's twice as much service or if it's because the locations people are going to the different medical offices. We don't have that kind of information at all. Then we were asked to look at splitting the route into 2 routes between East Street and Farmers Lane and providing hourly service on each one. This got hard to plan because each version has a different running time. So instead of having a route that's coming through, say, every 60 minutes, we'd have one coming through at 55 and one at 65. It becomes pretty tough to schedule, and it looks really bizarre on a schedule for passengers, for people riding. We tend to like to look at every 20 minutes, those kind of things that we all think about in our lives, but every 65 or 55 minutes is a little off. Notwithstanding the Route 11 we were talking about, we know that one's off because it's the only way we can do it. And the other part was, we thought create a lot of confusion for people. Well, do I catch this bus this time on Sonoma or do I catch it on Montgomery? Because they'd be running opposite. One would be running on the hour and one would be running on the half hours. So people sort of tend to miss the bus if they're not at the right stop. And we just felt that was going to cause some confusion that generally doesn't work very well. And it goes just back to that stronger transit corridor. Sonoma is just a great transit corridor for this kind of service. And then we looked at splitting the route into one-way couplets between East Street and Doyle Park Drive. So they'd come in, the bus would come in on Sonoma, turn on Doyle Park and catch Montgomery and come on downtown. We went out, actually Rachel and I went out, we walked it, we checked it, we counted the spaces. We'd have to take out 15 spaces on Doyle Park Drive because it's so narrow. And our parking staff informed us that probably would cause a lot of concern in that neighborhood because parking is already so tight. So basically, we didn't pursue that much further, but again, we lose that idea of bi-directional service and easy for people to understand on Sonoma Avenue. So we're back to the original idea of consolidating the service on Sonoma Avenue, bi-directional 30-minute service. It's direct, faster trips between Montgomery Village and downtown. And then we have that complimentary service on Montgomery by the county that helps fill in that gap. So that brings us to our recommendation, which is to adopt by resolution the original proposal for the 4A, 4B alignment. That's on Sonoma Avenue. Our recommendations for the original proposal on the western terminus of Route 11, the Apple Tree Drive, Peterson Lane, and the extension of Route 11 to Stagecoach Road and Fountain Grove Parkway. We also are asking, we told the neighborhood we would do this, that you direct us, so it's on the record, that we meet with the neighborhood, Apple Tree neighborhood, after 3 months of route operation to go back and see how it's really operating through the neighborhood. Do you have any more questions?
Council, questions before we move to public comment? Okay, let's move to public comment and then bring it back to the council. Denise Lee, and Denise will be followed by Dorothy Press. Is Denise here? Oh, there you are. Thank you.
I'm sorry. Okay. Hi, my name's Denise, and I ride the number 2 right currently to Memorial Hospital. I have many health problems, and for the last 5 years, about 3/4 of the year, I go there twice a week. My health care depends on the number 2 bus to Memorial Hospital and the surrounding buildings, and I use many of them. So today I'm low income. I paid a cab to drive me down Sonoma Avenue to look at the bus stops. There is no crosswalk across Sonoma Avenue at Doyle Park. It's a very wide street. There are 2 stops, one on each side. There are 2 small benches, maybe enough room for 2 people, but no crosswalk. Let's see. I would hope that the city of Santa Rosa would keep a bus going to our city Memorial Hospital. It's medical care. And Montgomery Drive and the medical office there, they do have services there that Sonoma Avenue does not have. Okay. As a person with mobility issues, there are days that mobility is highly difficult, and walking from my appointment on Montgomery Drive to the bus stop would sometimes not be available to me and be very difficult. And also I do qualify for paratransit, but I cannot afford paratransit. And the other thing with the paratransit in this city and county is that you have to book 7 days in advance. Currently, there might be more ridership on the Sonoma Avenue because the bus runs every half hour. Currently, the number 2 runs once an hour. I did look into the county bus. It runs, I would be waiting 2 to 3 hours for the county bus to go back to Montgomery Village, which then takes me back to Bennett Valley. And this meant a lot to me. I have to pay a cab to get home, and it's $25. So thank you.
Thank you, Ms. Lee. Dorothy Press, followed by Thomas Piazza.
Good evening. I'm Dorothy Press. I've been here 4+ hours like we all have. Thank you for being here and addressing this issue that we have. This is my second city council meeting, and I did attend an off-site meeting. We received a letter stating that they were going to have the off-site meeting off of Stony Point Road about 4, maybe 5 days prior to the meeting. So a lot of people didn't show up to it due to the time that we got the letter. I went to the meeting just, upset, not wanting it, living in the neighborhood since 72, growing up, going to Pioneer High School, not wanting a city bus going in front of my street. So I had an open mind. I wanted to hear more, and they said, "You're welcome to ride the bus." And I told my husband, I'm not riding it. I had a negative attitude. I'm not going to ride it because I don't want it in our neighborhood. Why would I want to ride it? He goes, just have an open mind, ride it, and see what you think. So I got on the bus. We went down Guerneville. We turned right onto Fulton, and it's just a one lane. And then it opens up to 2 lanes. And the bus driver went to turn onto Appletree, which he had to go into the lane next to us to make the turn. And when he went over the turn, he did hit a couple of the bumps. And I said, oh my God, he just hit the bumps. Then I thought, if there's a car parked right there at Appletree in front of those people's house on the corner of Appletree and Fulton, and there's a car turning onto Fulton heading west, the bus is going to hit the car. And unfortunately, there wasn't a car parked there for us to say, look, this is the reason why you shouldn't be on here. And then as you go on to Appletree, we went down, and riding up in the back, I looked out, and it's like, yeah, he's got clearance, but there's still an S-turn on Appletree Drive. And there's seniors that walk their dog. There's people that ride their bikes, and isn't there a clearance? The bikes are supposed to have 3 feet in between the bus and the cars. There's also, you're going to put money into Appletree Drive as far as we're going to need crosswalks because Pioneer kids run from Appletree Drive Yardley onto Appletree. And there's also no crosswalk from Appletree onto Peterson, because they'll be turning right onto Peterson, and there's no crosswalk there. I also brought up to the gentleman that was on the bus that works for the city, and I said, have you pulled the accident report on Peterson and Guerneville? And he said, yeah. And I said, so obviously you'll see that there's accidents here all the time. And he said, yes, but it's not the bus driver's fault. We've already looked into that. I said, well, yeah, I'm thinking it's not the bus driver's fault, but you're putting people's life in jeopardy. So I wish I had more time. Thank you.
Thank you, Ms. Press. Thomas Piazza, followed by Don Barbieri. Hold on a second. Oh, Mr. Piazza, you're on now.
Thank you for giving me the opportunity to speak. And that was my darling daughter. She took the words out of my mouth. If you're going north on Fulton Road and you get to Appletree, there is a stoplight there with a green arrow if you wanted to make a left-hand turn. So the bus could make a U-turn there. I've got a couple of concerns. One, my daughter brought up about bicycles. We have a lot of youth and adults riding bikes on Appletree and also Peterson. And like she says, a bus or any vehicle has to give them a 3-foot right-of-way. With that bus giving bicyclists 3-foot right-of-way, part of that bus will be in the oncoming lane. And that's something I don't want to see happen. Also, the roads on Appletree Road and Peterson, they're starting to show wear and tear. A comment was made at one of the meetings that we have garbage trucks come in. Well, the garbage trucks come in on Monday, and there's 2 of them. One picks up garbage and recycle. The other one picks up yard waste. But that's only twice a week. Well, these buses are going to come 6 times a day, so that's 30 times a week. These buses are going to be going down Appletree and also Peterson. These roads are not designed and made to take that kind of wear and tear. And like my daughter says, there's no actual crosswalks either the only crosswalk that I think there is right at the corner of Fulton and Appletree. But there is none on Appletree, there is none on Peterson. Get a lot of people working. My wife has a daycare. She walks children to the park on Yardley. And, it's not designed to have public transportation. coming down the road. Granted, they're not going to make any stops, any pickups or drops off, granted that, but it's just not designed for having buses going in that area. Thank you.
Thank you. Don Barbieri?
I'm right here.
There you are.
Next slide. Thank you, council, for meeting with us tonight. One of the questions that you asked was about safety. And that's, I think, one of our primary concerns with Apple Tree is safety. I too rode the bus that evening along with the residents that are here with concerns, along with a few others that were not there. As we drove turn on to Apple Tree from Fulton Road, one of our concerns was where the road narrows. And with that narrowing, the bus was actually in the lane, and a car came to the right of the bus, came around and cut the bus off. So it was perfect because that's what we experience on a daily turning onto Apple Tree. My understanding is the road is not going to be widened prior to that bus turning. Like Ms. Piazza said, the bus, another concern was, the clearance of the bus and having people be able to ride down our street, because we do have a lot of bike riders, we have a lot of retirement people that live on the street, and there isn't enough clearance if you're getting in your car. So that was one of my concerns I addressed while we were on the bus. And they had said, well, it would be the pedestrian's responsibility to wait. And I understand that, but when you have a bus coming through, and you don't see it, it's your fault if the bus doesn't see you. And so we asked him to come back around again because there were issues that we did not address while we were on the bus, on our little field trip on the bus. As we came back again, we had the bus stop to make note of our concerns that we have had addressed with them. And in doing so, it was, they were able to see, we had them stop on the blindsided turn that was our concern, and they were saying, well, the bus is much bigger than a car, you'll still be able to see around. So when we rode on it, and I actually rode in the back of the bus, which is like a 2-step lift, you still couldn't see it, and I addressed that with Rachel. So one of our suggestions was the Rayleigh Shopping Center. When my neighbors could attest, that shopping center in the back, that lot is empty. Maybe a few cars in there, nothing like the Sweet Tea's parking lot. I've gone there for lunch. I mean, it's not even nearly as many cars in that back lot as there are in that shopping center that you're thinking about turning around. Another suggestion that we came up with was Country Manor across the Arroyo Drive where the hospital is. We all, myself and I think a few other neighbors, drove that to see. Yes, it's a one-lane road and it comes right out onto Guerneville, but it would be perfect turnaround. I mean, if they drove it, we asked to drive it, and they wouldn't take us through there. So, thank you.
Thank you. Steve Abrams, followed by Linda Adrian.
Howdy, folks. You've heard most of the concerns that we all have. When we were on the bus and it made the right turn onto Apple Tree, you heard about the cars passing on the right. What you didn't hear is we went around again, we did it again, didn't have that problem, but a car was on Apple Tree heading west at the traffic light. The bus had to make a sharper cut turn to avoid having contact with that stopped car. If in fact there is a car parked on the corner house on the south side of Apple Tree, it's going to be a very difficult right-hand turn that he's going to have to make. Anytime we went by a car that was parked on the south side, he was across the center line in the middle of the road. 2 cars parked on either side, across from each other, the room gets even smaller going down Apple Tree. I just want to try to clarify, because you really look confused when we were talking about that back lot at Rayleigh's, where you make the left turn at Apple Tree. You go all the way down, you make a left turn into this parking structure, and then this small parking lot has no more than I've ever seen 10, 11 cars in it. And I know if Rayleigh's was approached, they might have to give up a parking row so that the bus could come in and turn around during those hours to go back out. And if that could be negotiated with Rayleigh's for the time frame that these buses are running, I don't see that there is a problem using that back lot. Like I said, it's never been full. There's never more than 10 cars, 11 cars there. Making the U-turn seems to work. I don't know why it would have to. I understand that there's some safety issues, but I think the back end of that Rayleigh's is probably a better idea. The city of Santa Rosa, for a long time, I've lived there for 40 some odd years. It seems that they found a way to get out of the neighborhood on the east side of this terminus for them. We only want what they're getting is that we don't have the buses coming down our neighborhood streets for all the reasons you've heard. It's just, for us, it's not something that is going to be tolerated well at all. Thank you.
Thank you. Linda Adrian, followed by Jerry Lalonde Burke.
Hi. Some of what I have doesn't really pertain to this, and part of the reason is I'm talking about 3 mobile home parks in Santa Rosa that are having their bus stops eliminated. And they never knew about it until maybe about a week or 2 ago. So when this came up in June, there was no idea that anything was happening. But Journey's End on Mendocino, they're eliminating. There's 3 senior parks that are going to have no bus stop in front of their parks anymore. And they're senior parks, so it's going to be hard for people to go anywhere. And one of them is the Sequoia, which is on Fulton. The other one is Journey's End, which is on Mendocino. And the one that I'm most concerned about is Santa Rosa Village, which is on Highway 12. And if you look at the revised phrase, if you look up on the top, up in the corner where it says Highway 12, yes, they're right there. What you did, there used to be a bus stop that went, a bus that went down that whole road to Safeway and Flamingo Road, which is a market for them to go to. They've eliminated that completely, so there's no bus running in front of them at all anymore, which means they would have to walk at least a half a mile over to Mission to try and get a bus. Now, we're talking about seniors that have walkers. There's no way, if I lived there and didn't have a car, there's no way I could get to a market. Because, I mean, there's just no bus going there anymore. As you can see, there's no line. And in one of the, on the presentation number 13, up in the corner, you can see where there used to be a bus there that went there. And because the other Safeway is clear on the other side of Calistoga Road, is where the 2 markets are. And you can see how far the Safeway is there. I mean, it's going to be almost impossible. And the only way they found out about it is one of the residents got on a bus, and the bus driver told her that he wasn't going to be stopping there anymore, and he thought it was funny and laughed. You know, I mean, I just don't understand. We have 3 senior parks across the thing that they're going to have if they don't drive, they'll have nowhere to have no way of getting anywhere. And that, especially the Santa Rosa Village. And once they found out, they're getting a petition together and everything, but it's so after the fact, I don't know what can be done. But we just found out about it a couple weeks ago. That's why I'm here. So, I mean, I don't know if I'm too late and we've just lost the bus stops or what to do. As I say, it's Sequoia on Fulton. It's Journey's End on Mendocino. And then it's Santa Rosa Village, which is really bad because there's nothing there now. Thank you.
Thanks, Linda. Jerry, followed by Steve Bertelbaugh.
Mayor Sawyer, council members, I want to start by expressing my appreciation to you and particularly to the city staff. I'm very pleased that Anita's here tonight, given her retirement in the near future, and that she's this thing is happening, and it's happening so well. And so I appreciate that. As a person at the east end of the 11 route, I think what they did was very good going up Parker Hill. It does serve that neighborhood. It will do all of the things that they're doing, and I appreciate that. Reimagine. No, wait a minute. No, I want to imagine. I want to imagine that we have less congestion, and I want to imagine that we have less air pollution, and I want to imagine that students have free bus passes. So we've waited for the 2 years for the Reimagine project, and we appreciate that. But I would like the city to set as its next goal the right kind of passes for students and veterans and people with disabilities. I want that imagination, because my real objective, after all these years, I want to imagine fareless transit. I want anyone who wants to get on a bus to be able to get on a bus. But in the meantime, let's have free student passes, okay? Thank you.
Thanks, Jerry. Steve?
Ooh. Thank you, Mayor Sawyer. Mayor Steve Bertlbaugh with the Transportation Land Use Coalition. We're at the very end of a very, very long process. Want to join in the commendation of the staff for pulling this all together. I am really interested to hear that a U-turn is outside the box and in the running here. We've heard from a few people that are going to be inconvenienced by some of these changes, and I really wish that didn't have to happen. I wish we had enough funding that we could serve everybody everywhere, and the fact is that we're struggling with that. We understand that there are things happening in Sacramento right now that are going to permit more funding in the long term, and that we'll be able to make some progress in all of this. But in the big picture, I want to commend all of you and all of the staff for getting us on this adventure to improve the bus service, to improve primarily the frequency of the service, and to wrestle with these last final concerns that are coming up and find a way through them. Thank you.
Thanks, Steve. Those are all the cards that I have on this item. I'll bring it back to the council. Questions, council? Sure, Ms. Combs.
Thank you, Mayor. And I do want to say thank you to the staff. And thank you to the staff that are present here tonight, and also thank you to Rachel Ead, who has really been out and about in public, doing some hard work. And I really want to appreciate you and her and the work of the department. I have a question about manufactured home park residents and other residents. If a stop is eliminated, for example, in front of a manufactured home park, are the residents notified that the stop will be eliminated? Do we have a notice process?
In the ordinary course of business, if we're canceling a stop or temporarily frequently have to not use a stop for construction or something else, we post the stop.
You post it on the stop?
We post it on the stop sign, yeah.
Okay.
In this case, we didn't post everywhere in the city where there was going to be a change, but we had information on the bus.
Right, I just wanted to know if the three stops, Journeys in Sequoia and Santa Rosa Village, got us something posted on the sign.
No, it's if we're going to cancel it, in the next few days. We warned them we're going to take it out of service. We didn't, in this case, not for a planning purpose. We did not post them.
Okay, I'm sorry to hear that.
But if I may, and I apologize, the Journeys Inn will have service. Route 10 will now. So initially, one of the original proposals did not have service to Journey's End. By the time we finished working with Route 10, there will be service there to the Journey's End.
So Route 10 will go on Mendocino? Okay, and Sequoia on Fulton?
I'm not sure exactly where that
It's
is.
across from the country on Fulton? Just south of College. So we looked at a bus turnaround possibility at the country?
We're going north and south on Fulton full length, from 3rd up to...
And there's a stop?
I don't know exactly where the, well, Steve, is there a stop there?
South of College, yes.
Yeah, all the stops that are south of College will still be there, and they'll be served actually more frequently than they are today.
Okay, so that just leaves the Santa Rosa Village and Highway 12. But before you go there, you've given us really good reasons why you've done what you've done. Let me switch, because I want to pick it up. Is there any way that, for example, the split route alternative on Montgomery can incorporate the Highway 12?
That's the service we currently provide. That's how we do it, is by splitting the Rincon Valley service. It's not as frequent as us, but that's another one where we were incorporating the county service to fill in, and the county buses do go both directions.
The county bus goes to Santa Rosa Village.
Yes.
Can you explain to me which of the routes is the 55-minute route and which is the 65-minute route? The split route on Montgomery and Sonoma?
Do you remember? Was it?
Because you mentioned...
If you were to split the 4A and 4B to have one go down Montgomery Drive, that would be the 65-minute piece.
The Montgomery Drive piece is the 65-minute piece?
Right, which isn't represented here on the map other than...
I got it.
Right, okay.
And the 55-minute piece is the Sonoma piece?
Yes.
Okay. I'm having a really, you know that this is, you're talking about this now because I had such a hard time with not serving the hospital directly.
Yes. And it's probably one of the things that we as a staff have struggled with the most. We wish we could do more. We wish Mr. Butterbau's reimagining was actually imagined and that money was available. But it goes back to the original principles of trying to put the bus service where the most demand is. And we knew going in that there would be some instances where some people would not have as convenient service as they now have.
So the county provides service on Highway 12 and to the hospital.
Yes.
And we have paratransit service that's available, but what I thought I heard was that it's more expensive than using the bus.
Yes.
For the rider.
Yes. The paratransit service, we're allowed to charge double the adult fare, not double the what we call the half fare for disabled and seniors, but it's double the adult fare. So the senior disabled fare on the bus is 75 cents. The adult fare is $1.50. The paratransit is $3, double the $1.50. And it's because of the cost and the kind of, it's a door-to-door premium service that costs.
But we're driving people who could take the bus to the paratransit service. So I would like us to have a conversation about when we force someone to have to make that change, why we also make them pay more. I would like to have that conversation at some point so that people who are forced because of these changes don't pay extra when they don't have service they can't use. I understand charging extra for people who have a service available, but not for people who don't. I'm really excited about the U-turn idea. I don't understand how a joint possibility could work. I don't know how you do that, so maybe at some point you might explain it. I would love to just see a 3-month of the U-turn. I'm very excited at the prospect of a new stop on Guerneville Road. And if we have a 3-month successful U-turn project, we get an extra stop. So people aren't having to cross Guerneville Road to get to a stop. And I think that's worth some safety points. I also am concerned philosophically. This is a philosophical concept, I know, it's late.
We're not going to sacrifice safety ever, so just...
Yes, I got that, but I think you get a safety piece bonus.
We would be more than happy to assess that. I just
Okay.
want to go on the record to say we never sacrifice safety.
I won't go there. It concerns me that when we impact a neighborhood with something, that they should benefit from it. And what we have is a neighborhood that's going to be impacted by bus service, bus smell, bus weight, bus noise, and they don't get a stop. They don't get their own stop, you know? So for me, there's a little injustice there in that people should benefit from a service that is impacting them. So that's kind of be that as it may. It doesn't make sense necessarily to put a stop right there. I understand that. But if we can do the U-turn and add a stop for people who would benefit, I would really like to see that. I want to say again, I'm really grateful that you're doing this. We have a crazy schedule. It concerns me to hold a meeting about transit changes at a time people who use transit cannot attend. Transit's not available after 8. I know it's a late meeting, 7. I know it's a late meeting, and I know it's our fault, but it seems to me we need to be more mindful of when transit meetings are scheduled, just so that we can make sure people who take transit can come comment. And I don't want that to dampen my enthusiasm for the work that you've done. Thank you.
Thank you, Ms. Combs. And most of the meetings that we've had about this topic have happened much earlier in the meeting time as opposed to this late hour. Luckily, they have happened during more normal times. Mr. Corsi.
Thanks. Just a couple questions. On Peterson Lane between Appletree and Kernville Road, there's a bike lane on the west side that disappears about halfway down there. If we decide to go through Appletree, will that bike lane remain the way it is? It looks like there's not even the right-of-way to expand it.
At this point in time, we would not be proposing to make any widening. I don't believe the right-of-way exists at that specific location, and so we wouldn't be able to take that action at this point in time.
Okay. There was also a question raised about crosswalks in the Appletree neighborhood. Would those necessarily be added, or is that pedestrian infrastructure adequate as you see it at this point?
I actually have an email that Rachel sent out to some of the folks from the neighborhood that were one of the meetings, that at the end of the day that the traffic engineer would be putting in a work order for crosswalks at Appletree and Peterson.
Okay. Just to make sure I understand, we had talked previously to some extent about the mobile home park on Highway 12. But tonight was the first time I heard anything about the stops at Journey's End and Sequoia Parks. But my understanding is those stops remain. Okay, and they'll have more frequent service.
The stops on College, or excuse me, on Fulton Road will, yeah.
Okay, Mendocino is still the same?
It maintains the same frequency currently.
All right. Thanks, those are all my questions.
Thank you. Mr. Olivers.
Thank you, Mayor. Can you go over the concerns you had again about the parking lot at the northwest corner of the Rayleigh Shopping Center?
I'd like to pull up the map a little bit. Where's was that far back? Okay, so just as a reminder, we'd be coming in here and circling around somewhere in here to come back out. So Rayleigh's actually suggested we look at it. And we started to talk to him about maybe having to take out some parking, but it's likely we'd have to do another parking study there to see if we could, because of whatever the requirements were on that development. So we don't know if we can. But I was actually out there the day we were doing this, and those parking spaces in different parts are longer than others. And where they're short for a reason, for travel space. So if you get a long vehicle that parks in them, then we can't get down between the parking lanes. Coming out, as we were standing there looking at the bus and looking at the parking and actually pacing it off, a couple cars came out. They were pickup trucks, as I recall, came out this way. Had they been there waiting to turn here, we couldn't have gotten through coming in. So it's, if it's full, it's clearly a problem, but even if it's not full, if cars are coming out at a time when we're trying to come through, it's just not quite enough space there without taking out some spaces and trying to make the turns a little bit different.
Yeah, it's difficult to see on your map there as to how many cars are back there, because I just don't see how that could ever be full, so it's hard to tell. I'm actually seriously rethinking the U-turn now, because I'm thinking about safety, and again, we're here making some snap decisions or throwing out some options, but my concern now with the U-turn, besides what I've already mentioned, it's the riders. I assume we could potentially have disabled riders on here, children. There's no seatbelts on this. I don't want this to be a Mr. Toad's Wild Ride, making that U-turn for people suddenly falling off their seat, or having the driver being distracted over what he has to do with driving and watching passengers that are sitting in the bus as that U-turn is happening, because a lot can happen during that maneuver. So I'm just getting a little bit uncomfortable with that now. So the reason I was asking about the parking lot was I was considering swapping that out as part of the test, is testing out that parking lot and the apple tree to see which was a safer bet. If there's room for changing some maneuvers around that parking lot, that might be the answer, because again, there's no unusual maneuvers if we can use that, whereas the U-turn is still an unusual maneuver, and it's not so much the surroundings, but also what's going on inside that bus that I'm concerned about too.
If it makes you feel any better, we wouldn't have said it's feasible if we thought people were going to fall around inside the bus.
Okay.
The buses are pretty stable, and actually, this is the man who went out and tried it, and we don't feel that there's a risk of that.
Okay.
We can't control what's going on around the outside, but we're getting ready to have a Safe Drivers Award banquet for our drivers, and the awards are phenomenal. They just have high records of very good safety.
Good. And then if we do move that direction, then I would ask that the assessment include input from the riders as well, as far as what that maneuver is like for them.
Their eyes might get a little big the first time they ride it. They'll be real surprised, but I think they'll be safe on the bus.
Thank you. Mr. Wysocki.
Yes, real quickly. Crosswalks on Sonoma Avenue. Should we consolidate that? Do we have crosswalks where riders would be going to Memorial, getting off and...
I have to apologize. I didn't expect that question. I don't have any photos. I don't really know anything about the crosswalks along there.
There is one in front of Maduro Park School. It's actually a lit crosswalk, a flashing stop. That's the only one that I'm aware of in that area.
We'd be happy to evaluate specific locations if they were brought forward to us.
I mean, yeah, it sounds like it's not a funding issue, because if Apple Tree doesn't need them at wherever it's going to be, should we not? I mean, that shouldn't be an issue. Should we decide to do that, I would hope. So,
As crosswalks are generally identified to channelize pedestrians, it's not necessarily a safety tool. It's a crosswalk can't protect an individual any more than a non-crosswalk. It's intended to provide a specific location where we want pedestrians to cross, more as a channelization tool than it is a specific safety tool.
it doesn't alert the driver that there's pedestrians?
It can. It can.
I don't want to argue the point, it's late. Yeah, I would love to see that U-turn trial, and let's evaluate it. And then thank you for your work.
Thank you. Ms. Combs? Nope, are you good? Okay. Well, any other comments, council, before? Let's have a motion first, and then let's entertain final comments. Unless you have questions. Sure.
So where I'm kind of landing on all this, I support staff's proposals for Route 4A and 4B and the eastern terminus of Route 11. But for me, the western terminus, I would just recommend let's stay out of the neighborhood. And I'd be open to seeing whether it be a 2 or 3 month trial period on a couple of them, maybe even try the staff recommendation through the neighborhood on a 2 or 3 month trial period and bring information back, because the struggle I'm hearing is that we're all trying to predict what the future of any of these outcomes. I gotta be honest with you, I'm struggling with saying it's okay at Sweet Teas, because that lunchtime crowd there, the happy hour crowd there, that's a packed parking lot compared to what's over at Rayleigh's. If we're saying it's good on the eastern, I can't see why it might not be good on the western. And so I'm open to so let's try it out, 2 to 3 months, come back with more information, see what the drivers say, the riders say, and hopefully there'll be no accidents anywhere, and then it's a little bit more information that'll help me make a decision. That's kind of where I'm landing.
Thank you. Sure, Ms. Combs?
Forgive me, I'm trying to understand. Did you say try the U-turn or try something else for 3 months?
Yes, whatever staff recommends, whether it be the U-turn, go through the Rayleigh's lot. What I'm looking for is more information, because again, all these options, I heard staff say it's operationally viable, and I haven't heard staff say that any of the options would be dangerous, more preferred methods. So let's get some information, and I'd be open to seeing a 2 or 3 month, whatever staff would recommend. How much information would you need to have to make a further recommendation, since this is all new, including the U-turn?
I'm going to give this a shot, and I may let my counterparts step in if I stray a little bit. Some of the challenges we have with Rayleigh's and the differences between that and Sweet Teas are, it's a more complicated parking lot. Sweet Teas is actually very simple in and out. It has 2 rows of parking on either side, and it's got a wide access lane through the middle. There isn't a lot of crisscrossing going on, and it's a single business that exists there. Whereas Rayleigh's Shopping Center has multiple businesses, multiple access points, and quite frankly, the Rayleigh's itself is a very busy Rayleigh's. It's well utilized. So there's a higher propensity and potential for bus pedestrian interactions and bus vehicle interactions at that site. So that was one of the ones that, quite frankly, between both our staff and the Rayleigh staff, was taken off fairly quickly going along the front of the Rayleigh Shopping Center. While it looks great on paper, operationally, it is much more challenging than at the other end where Sweet Teas is. So I just wanted to put my 2 cents on that.
And I appreciate that, Mr. Nutt. I just have personal experience with both lots. And the Sweet Teas lot, you have both cars, it's not that wide, especially as we were suggesting coming in the main entranceway, there's not cross traffic there. And if you make the left and the right, or either way you do it, you just have a bit of that parking lot, not the entire length. So we don't need to argue the point. I just made my offer. Let's give some tries.
So can I try to make an offer here? I think I'm beginning to sense that there's a consistency that we should try to avoid the neighborhood as much as possible. So what we'll do as staff is work out a testing scenario that looks at several of our testing, evaluates the criteria that we're looking at to provide the safest, most direct route. We have some options in front of us. We'll evaluate that over the next 3 months, and then we'll bring back the report to the council to make some decisions. There seems to be some places we could go, but but there is a desire to see if there's a way for us to avoid the neighborhood. That's what I'm sensing. We can take that under advisement and figure out an action plan to address that. That may include a run through the neighborhood. I'm not hearing that is off the table, but the desire is to evaluate all of our routes and see if there is a place that takes us out of the neighborhood and report back to council on that front. And so if that's the urging, I think that you can incorporate that into the motion and we'd be able to respond to it. If you don't want us to test the neighborhood, you want us to test the alternative routes only, we'll be open to that too. But I guess that gives us some scoping in the conversation.
Mr. Wysocki.
Why would you test the neighborhood if the test outside the neighborhood goes well?
Well, again, I'm looking for, I said we can have either direction here.
That's my
Councilmember.
preference.
So, Mr. Oliveris, you have this item. You want to give given the most recent conversation, and then we can get final comments perhaps. But let's give it a first shot at this motion.
Well, I'll give it a first shot here. I don't think I captured everything in place, but I'll move a resolution of the Council of the City of Santa Rosa to adopt alignments for city bus routes 4A, 4B, and 11 with necessary testing and evaluation, and to return to council for final adoption. Do we have a date certain or a period of time?
I think what would be best is if you gave us a period of time and said, and asked us to return to council.
So I'm not specifying the number of testings as far as alternatives, so you need to determine that and bring it back to council with a recommendation.
That's correct. That's perfectly fine. I think City Manager McGlynn's comments, if you had specific restrictions, we would like to hear that as well.
Okay, and I don't want to give a date specific because I need to make sure that the testing is done appropriately. And wait for it to read the text.
I will second it, but I would like to ask, I had made a request that information come back regarding the ability of us to not charge the same fee for people who are forced to paratransit.
That's a budgetary item.
Yeah.
I think we can bring that back in a budgetary conversation, or you could do a motion separate, but I don't think that's not really what's
Okay,
under
so that's not
discussion.
coming back in 3 months or whatever time period we're talking about maybe.
Well, again, I'm more than willing to entertain a separate motion on that
Okay,
front to
I will
get into it.
I'll second this motion and entertain another one.
Okay, so I have a motion and a second. Final comments, council. Are you comfortable with the motion at this point? Yes? Your votes. And I have 6 ayes. Thank you. Look forward to the test.
Mayor Sawyer, if I could just ask a clarification on what was approved. I did not hear a restriction on the testing locations.
I ask that you determine those testing locations.
Thank you.
We encourage you to try non-neighborhood locations, but we are not limiting you. And I was going to, is it appropriate for me to make the motion?
Well, as is council, you can put out a motion, get it seconded, and bring it back for the next council agenda to see if you want to add to it a future agenda item.
Okay, I'd like to move that we discuss the costs of using paratransit for individuals who, because of our reimagining bus, do not have access to the bus route anymore.
I have a
Second.
motion. I have a motion and a second. That's all it takes.
Thank you.
Mr. McGlynn, the second public hearing of the evening, 14.1.
14.1, public hearing, placement of the annual stormwater enterprise charges on the Sonoma County property tax roll. Heaven Moore, supervising engineer, presenting.
Welcome, Ms. Moore. We're looking forward to an expedited report.
Absolutely. Good evening, Mayor and members of council. I'm Heaven Moore, supervising engineer for Stormwater and Creeks. The public hearing that we're bringing forward tonight is for placement of the annual stormwater enterprise charges onto the county property tax roll. The stormwater enterprise was created by council in 1996 and is in accordance with Title 16 of the City Code. It provides funding for our NPDES, which is our National Pollution Discharge Elimination System permit, which is our stormwater regulations, as well as activities like creek restoration, stewardship, flood protection, public education, storm drain maintenance, and a whole slew of our other programs. The calculation of this assessment is based on equivalent residential units. This calculation takes into account a property's size, the land use designation, and amount of impervious surface of that parcel. The equivalent residential unit value or cost each year is actually adopted during the budget process. So this is something that's come before you previously. And this year it is $31.60. In order to simplify the payment process for each parcel within the city of Santa Rosa, we are bringing this item forward for the collection of that in the same method and time as the property taxes are collected. This assessment would be collected on behalf of the city by the County of Sonoma. And this is how this assessment has been collected since it was created in 1996.
We're getting a signal that it's hard to hear you over the televised version. Can you please make sure the mic is close? Thank you.
Absolutely. It is recommended by the departments of Santa...
Hold on 1 second.
Sure.
Thank you. Go ahead.
Okay. It is recommended by the Department of Santa Rosa Water and the Finance that council by resolution adopt the Stormwater Enterprise Charge Report and approve placement of the Stormwater Enterprise charges on the Sonoma County property tax roll to be collected by the Sonoma County Assessor Controller in the same time and manner as the Sonoma County property taxes are collected.
Thank you.
Happy to answer any questions.
Appreciate your brevity. Council questions?
Somebody should ask
Did you say
something.
yes? Okay. Since we have no questions from the council, I'll open the public hearing. There is no one from the public in the chamber, so I will close the public hearing, bring it back to the council. Any final questions, council? Seeing none, who has this item? Do you have Mr. Corsi?
Yes. I'll introduce a resolution of the Council of the City of Santa Rosa approving and adopting a report for a proposal to place stormwater and drainage charges on Sonoma County property tax roll for collection with county property taxes, fiscal year 2016-17, and ordering that city's annual stormwater enterprise charges be collected on the Sonoma County property tax roll and waive further reading of the text.
And I second that and apologize for having you wait so long this evening.
Thank you. Appreciate it.
Thank you. I have a motion, second, and your votes. And we have 5 ayes with council members Carlstrom and Wysocki absent from the chamber. Yes, Mr. Corsi. We'll have to reschedule the proclamation. So yeah, that was evidently the recipient was scheduled to be here, but not available evidently. And I have no cards for our final public comment. We are adjourned.
Santa Rosa, out there in the middle of everything.
In recreation and parks, the days begin.